morning to everybody. As you know, I'm Zoe Hill. I'm the Inspector appointed by the Secretary of State to conduct this inquiry and to make a recommendation to him, and that's a decision that he will then subsequently make. It relates to the London Borough of Barnet, West Hendon Regeneration Area Consulting Purchase Order 2014, number 1. A few housekeeping matters to run through. If we can start with mobile phones turned silent or similar equipment turned silent. Recording of the event. I can see the Barnet Bugle here. Anybody else? And you are? Thank you. Anybody got any problems with recording of the event? Sorry. Thank you. As far as I'm aware, there's no fire alarm testing today, so if the fire alarm goes off, I hope you all know the procedure now, either out through the doors at the back or along the corridor and meet at the front of the library. Is the attendance list out? I guess all right here. Thank you. Make sure that I have that at the end of the day, or it goes to Ms. Norton. In terms of where we go now, we need to just have a quick check for documents. And then we're moving into the closing stages of the inquiry. The only thing that I have outstanding is the letter from Rosie Moore dated the 18th of November 2014.
So I thought you already had that somehow. We've got a...
I haven't. I thought we were going to get that.
No, that's fine. We'll, well, it's a letter of the 17th.
The 17th.
Hang on a second. Let's just try and... we can do this very briefly. Is it in 42 now? Sorry about it. It's the 70th. I believe, and I will make sure that this is correct, but in inquiry document 42, there's a letter dated the 17th of November from Rosie Moore
to
Mr. Knowles, and I believe that's the one you're after. Is that right? Or it's a different one?
If I can have a quick look at that.
Okay, thank you. You're also going to get an updated schedule of negotiation.
It's important that I have that, so it's a sort of final position at the end of the day. It's probably the only thing at this stage that I'd be likely to accept if there's an update between now and closing submissions coming to me next Tuesday. Will literally be what's read out today. If there's any change to the position really at the end of the inquiry, that's the sort of piece I want to know.
Yeah, I mean, you're going to get this document today before the inquiry closes. I don't think it can happen between now and next Tuesday. We'll sort that out later.
Have you had a chance to have a look?
Yes, that's fine.
Okay, that's fine. Right, that's that one. Any other documents to hand in or procedural matters that I need other than that revised negotiation schedule?
No.
Okay.
Any other interested parties wishing to speak who haven't done so already? Okay. Well, we'll move on then to closing submissions. And as I said yesterday and at the pre-inquiry meeting, it's a straightforward order in which I hear people. So anybody who's here is an interested party who wishes to speak first, followed by the representatives and statutory objectors, and then the inquiring authority. So anybody here who wants to say something by way of closing remarks for the interested parties? In which case, Mr. Knowles, I understand you're making the closing submissions for yourself and this party.
Can you say a few words? I've got a few words to say.
I expect the bulk of the final statement will be from myself. Just pass the same few words afterwards, and I'll hand this over.
Thank you.
It is a little longer than I envisaged, so apologies for that.
As as was agreed at the pre-inquiry meeting, I expect that submitted electronically for Tuesday. It should be exactly the same document. There should be no changes to it from that.
So.
It will just be myself and the objectors I'm speaking.
Okay. It doesn't matter. If you want to change your minds, just add a little bit at the end. We'll just hear from Mr. Knowles first, okay? In your time, Mr. Knowles, are you all right with water?
Yes, this statement is made on behalf of leaseholders who are remaining objectors and who my firm represents. With permission from my fellow residents advocate, Yasmin Parsons, my statement will also cover a number of issues that tenants on the estate have raised throughout the inquiry. This statement covers issues raised verbally and in writing to the inquiry. I understand that Ms Parsons may wish to say a few additional words after my statement that I'd like to go into. Public interest. It is accepted as a test for whether the London Borough of Barnet West Hendon Regeneration Area Compulsory Purchase Order No. 1 2014 should be confirmed or not is intrinsically linked in part to Section 17 of Circular 06 2004. For the purpose of the inquiry, and more particularly for clarification to lay members present today, I shall quote this in part. A compulsory purchase order should only be made where there is a compelling case in the public interest. An acquiring authority should be sure that for the purposes for which it is making a compulsory purchase order should sufficiently justify interfering with the human rights of those with an interest in the land affected. Regard should be had in particular to the provisions of Article 1 of the First Protocol to the European Convention of Human Rights, and in the case of a dwelling, Article 8 of the Convention. Article 1 is merely a provision advising that Section 1 applies, within which Article 8 states, everyone has the right to respect for his private and family life, his home and his correspondence. There shall be no interference by a public authority with the exercise of this right, except such as is in accordance with the law and is necessary in a democratic society in the interest of national security, public safety, or the economic well-being of the country, for the prevention of disorder or crime, for the protection of health or morals, or for the protection of rights and freedom of others. That's Article 8 of the European Convention of Human Rights, Council of Europe, 1950. It is the objector's position that there is not a compelling case in the public interest for the compulsory purchase order, and that there are private rights specified within the Convention that would be interfered with if the compulsory purchase order is confirmed. It is accepted that to interfere with the private rights specified within the Convention, there needs to be an overriding public interest. In this closing statement, I shall draw on evidence submitted to the inquiry verbally and in writing to suggest that the public interest test has not been met by London Borough of Barnet, which I shall call the acquiring authority. And further, that the loss of rights held under the Convention are not proportionate to the benefit to the public if the order is confirmed. Firstly, I shall turn to address whether the proposed development envisaged by the acquiring authority and by Barnet Metropolitan LLP, who I should refer to as the developer, is in the public interest. There is no denying that there is a shortage of housing and that the development will go some way to bridging that gap. Similarly, there is no denying that with an increase in density and the likely increase in spending power from the estate, that there would be an economic benefit to the area. The objectors contest whether the makeup of the development and the manner in which increased spending power is utilised is in the public interest, as required by Section 17 of Circular 06 2004. On the issue of makeup of housing, we've heard that only 25% of the housing will be affordable under the definition from the Mayor's Office. Of that, 43% will be social, with the remainder mixed between affordable rented properties and those made available for shared equity purchase. My next section is about affordable rented properties. The definition of affordable renting, we've heard, comes from the Office of the Mayor of London. More particular, it is 80% of market rent. The acquiring authority has suggested that the estate suffers from deprivation, citing a government index for justification. Accepting this government index as correct, this would leave rental levels in the bottom few percent within the borough. Market rent on local authority estates will of course be largely influenced by the local housing allowance rate, which Mr Dismore referred to when assessing affordability. This rate is of course set as the 30th percentile of rents within the entire borough. As such, even with a 20% discount on market rent, this affordable rent would in fact be unaffordable for many within the area and of course those currently residing on the estate. Mr Dismore further suggested that the affordable rent is actually not affordable given the average salary within London. For those tenants on the West Hendon estate who do not qualify for rehousing but wish to return to the estate, taking one of the affordable rented properties, many are likely to be priced out of their potential to do so. As Mr Dismore suggested, the rents will be, in many cases, approximately twice the level of the social rented properties they currently occupy. In addition to this, the level of service charge may make it prohibitive for the wider community to afford to move into the new developments. At this stage, I'd like to point the inquiry to Section 6 of Appendix A in Circular 06/2004, more particularly described to as the well-being power. For ease of reference, I've quoted the pertinent section below. The wider power in Section 226, subsection 1, subsection A, is subject to Section 226. This provides that the acquiring authority must not exercise powers unless they think the proposed development, redevelopment or improvement of the economic, social and environmental well-being of the area for which the acquiring authority has administrative responsibility. The part of this section which I would like to draw to the inquirer's attention is the last few words, namely, for which the acquiring authority has administrative responsibility. I do not believe it is contested that the administrative responsibility of London Borough Barnet is the area within the borough boundaries. However, the objective do contest whether the properties in the new development will be affordable for those who currently reside within the administrative responsibility which the London Borough holds. Appendix 2 of my own evidence in chief provides estimated annual service charge levels averaging at £1,626 for one-bedroom properties and £2,098 for two-bedroom properties. To put these in perspective, I have used the information supplied in the final week of the inquiry by Mr Calladine on assessment of service charge subsidies. The average one-bedroom service charge within the borough for a new build affordable unit is £1,000. I have already stated that the new development averages £1,626, some 62.6% higher. The average two-bedroom service charge within the borough for a new build property is £1,440. I have already stated the new development will average £2,098, some 45.7% higher. The subsidies, of course, do not apply to households from outside of the estate who take an affordable rented property. The increases are even larger compared to the service charges on social rented properties, which the London Borough, within the borough, where the increases will be 132% higher for the one-bedroom units and 110% higher for the two-bedroom units. Coupled with the particularly high standing charge from E.ON for the hot water system and the high ground rent, both quoted in the same appendix to my evidence in chief, This makes properties unaffordable not only for those currently living on the estate, but also the comfortable majority of potential residents. The public interest test in Circular 06/2004 is not met, in my opinion, when the portion of the public who could benefit from the development is restricted to a very narrow section of wealthy individuals, many of whom may come from outside the area of administrative responsibility referred to in Section 6 of Appendix A to the circular. It neither benefits those currently living on the estate, who have been described as living in deprivation, nor those in the wider community, the majority of whom will be unable to afford one of the new units. My next section is about social rented properties. It is the objector's position that the proposed development has an insufficient amount of social rented properties. The overall scheme relates to circa 2,000 properties. Taking the figures of 25% of these being affordable, that being 500, and of those 43% being social, that would provide approximately 227 social rented properties. It has been stated to the inquiry that there are currently 679 residential properties on the estate. Of these, 110 are still in private ownership, with the remainder owned by London Borough of Barnet and Metropolitan Housing Trust. These numbers should be consistent, I should say rather than consistent. These numbers should be consistent with evidence provided to by others. This leaves 569 properties capable of being rented either by London Borough of Barnet or a registered social landlord in Metropolitan Housing Trust. The reduction of social rented properties from 569 to 227, a reduction of 60%, is not in the public interest, again failing the requirements in Section 17 of the circular. The need for social rented properties is even greater once it is considered that London Borough of Barnet are undertaking similar regeneration schemes on its other large estates at Stonegrove, Spur Road, Dollis Valley, and only a mile or two away on the Graham Park estate, which is by far the largest of the borough's estates. There has been repeated referral to the London plan, both in terms of density and provision of affordable and social housing. It is, of course, not the inquiry to assess the planning application, but rather the development, should it proceed, whether it will pass the public interest and well-being test within the circular. To assess what the public interest is, the London plan, created under instruction from publicly elected officials, is a good starting point. I would like to refer the inquiry to Section 3A.9 of the London plan, titled Affordable Housing Targets. For ease of reference, I've stated it below. DPD policies should set an overall target for the amount of affordable housing provision over the planned period within the area, based on an assessment of all housing needs and a realistic assessment of supply. In setting targets, boroughs should take into account of regional and local assessments of need. The Mayor's strategic target for affordable housing provision, that 50% of provision should be affordable, and within that, the London-wide objective of 70% social housing and 30% intermediate provision, and the promotion of mixed and balanced communities. They should take into account of the most robust available assessment of housing capacity and of potential sources of supply. The 50% target for affordable housing has not been met, with only a 25% provision. Within the provision that is provided, it is recommended that 70% should be affordable. The planning approval, however, at West Hendon is 43%. Furthermore, the Mayor's Supplementary Planning Guidance, SPG, on housing suggests that large residential development sites should be assessed in isolation as to the amount of affordable and social housing. The suggestion by London Borough of Barnet that more privately owned properties are required to alter the tenure to a tenure mix which Mr Wild referred to is therefore not applicable to the West Hendon estate, which should be assessed in isolation. Paragraph 3.29 of the SPG states, new developments of 500 homes or more should be large enough to set their own context. They should therefore be able to provide the basis for more mixed and sustainable communities as set out in the LP, Policy 3.8.8, and should take into account of the need to maximise affordable housing output, and within this recognise the priority attached to affordable family provision. That's paragraph 3.9 of the Mayor's Supplementary Planning Guidance. Clearly, as the proposed scheme is for approximately 4 times the 500 homes referred to, the guidance applies to the West Hendon estate. On the basis of 2,000 properties, this leaves the London plan requiring 700 social rented properties, whilst if the order is confirmed, we will have approximately 227, slightly under a third of the requirement. Not only has the London plan target been missed, but so has the target set by the London Borough of Barnet. Clearly, there is a need for social housing within the borough. If the compulsory purchase order is confirmed, it will be difficult to meet the needs suggested in the London plan. The scheme proposed under the order does not comply with either the public interest or the wellbeing test in the circular. Section 4 is private sale properties including shared equity provision. We have heard on a number of occasions during the inquiry that the properties are unaffordable to those living nearby or on the estate. My earlier points about affordability apply equally to the purchase prices, so I won't repeat them. The issue of the shared equity provision, however, is of particular concern. There is largely an absence of affordable properties near to the estate for leaseholders to buy, an issue in part because of the ambitious plans by London Borough of Barnet to regenerate its largest estates. In circumstances like this, it is common practice for developers to offer a shared equity scheme. Where viable, this enables leaseholders to remain on the estate if they wish to, and also enables the acquiring authority to suggest they are meeting the requirements within the circular. However, on this regeneration estate, it is the objector's position that the option is not viable. Of the 10 properties made available, only 1 is affordable to the 19 leaseholder clients that might be qualified, out of 22 across the face. This is on the basis of the purchase price and home loss compensation being required to make up a 50% payment of the purchase price. The other properties are also affordable, but only if an arbitrary incentive payment is added, and even then, only with the bare minimum of 50% being taken. The incentive payment is, however, linked to the withdrawal of the objection to the compulsory purchase order, and that is time limited. The inquiry may think it a coincidence or not that the deadline after which the incentive payment is to be drawn was extended during the inquiry to the last scheduled day of the inquiry. It has since been further extended, but only by approximately 1 month. We have heard from a number of witnesses who have suggested that there are a large number of elderly leaseholders on the estate. The ability to raise additional finance will therefore be restricted. It is, of course, not for the inquiry to assess property values, and nor should it be. If the suggestion by Mr Watling that the financial offer for the purchase of the property will not be increased is to be accepted as correct, the shared equity provision is unviable. Once the incentive payment is withdrawn, there will only be 1 affordable property for my 19 qualifying clients. Though the service charge subsidies are no doubt appreciated by leaseholders, they still remain far higher than both what they have been paying and the average service charges for new build properties elsewhere in the borough, according to the evidence provided by Mr Callaghan. Shared equity provision may therefore be an unviable option for leaseholders. Given that the service charge subsidy was one of the original pledges over 12 years ago, and that details of it have as per my own evidence in chief, been requested but not provided on a number of occasions. It is disappointing that it took until the final week of the public inquiry to establish how the subsidy would work. Section 5 is viability. What's that about? Try through a glass of water.
Need some more pouring.
Sorry?
I just want to have enough water for us to know.
Oh, yeah. Oh, there's more there.
Yeah. Viability has become an often repeated issue in the inquiry, repeated by both promoters and objectors. The promoter has suggested that the breakdown of housing in the proposed development between private sale and affordable housing is due in part to the viability study. The same study is used as justification for the amount of social housing provided within the affordable element, and that shared equity units will also comprise part of the affordable element. It is the promoter's position that it would be unviable to build more affordable, I should say affordable properties, and in particular more social homes is to be accepted. Then it is for the inspector to recommend and the Secretary of State to decide whether the development will meet the public interest and well-being test within the circular. Given the numbers and proportions within the planning approval, and given the requirements under the London Plan, I have already detailed why the objector's position is that the tests are not met and the order should not therefore be confirmed. There is, however, the Council's unitary development plan referred to by Mr. Wild, which does suggest that the West Hendon estate is an area allocated for regeneration. It is not the objector's position that the estate should never be regenerated. It is the objector's position that the approved planning permission for redevelopment of the estate does not comply with the circular. There is every possibility that another scheme could comply. To this end, the request for the developer's viability report to be released in full has been made. Without independent assessment of the viability, it is impossible to know whether a scheme with a larger portion of social and affordable housing could have been provided, a scheme which may satisfy the requirements of the circular. For that reason, it is the objector's position that the inspector is not in a position to confirm the compulsory purchase order, and as a result it should not be confirmed. We have heard from Mr. Turner in regards to the justification for release of the viability report, and I've also seen the promoter's position statement in response to this. We have heard that the inspector relied on the viability report in the London Borough of Haringey, Northumberland Development Project number 1 compulsory purchase order. We've heard that the inspector recommended the order was not confirmed as the viability report identified that a greater portion of social housing could be built than was provided for in the planning permission. Though the Secretary of State ultimately disagreed that the order should not be confirmed due to a balance of other considerations, he was nevertheless critical of the developer. There ensued a disagreement between Mr. Turner and Mr. King on whether the requirements to disclose the viability report, as has been the case in planning cases under section 226 subsection 1 subsection B of the Town and Country Planning Act 1990, applied here as the order was made under subsection A, not subsection B. It is the objector's position that the requirement to disclose is equally relevant under subsection A. For this, I point to two issues. The first one, the Haringey CPO was in reference to the construction of a football ground for Tottenham Hotspur. Was an order made under subsection A, the same as West Hendon. I've already referenced how the viability report was key to the inspector's recommendation. The second point, the difference between subsections A and B being a moot point that make little difference as to the purposive approach of interpreting the court's judgment, but simply subsection A confirms the position where an acquiring authority desires powers of acquisition to carry out development, while subsection B confirms the position where an acquisition is required to achieve interest that the planning policy requires. For the scheme in front of us to proceed, clearly acquisitions would also be required to permit the Planning Commission to be acted upon. Mr Turner also helpfully referred to R on the application of Perry versus London Borough of Hackney, where the High Court is currently considering whether the respondent was obliged to release the liability report to the objectors under the Local Government Acts. Mr Turner has advised that during the hearing, Mr Justice Collins advised that had the promoter not released the liability report, the Secretary of State would have no defence for approving the scheme. Though accepted that the statement was likely to be made in obiter dicta, the case has not yet been decided. It is unclear, therefore, whether it will in time afford part of the ratio decidendi and therefore be binding. However, even in obiter, it is persuasive. One of the most well-known legal principles, that of promissory estoppel, was in fact an outcome from a statement made in obiter dicta, said by then Justice Denning in Central London Property Trust versus High Trees House Limited. As the inquiry is aware, the objectors have made requests under the Freedom of Information Act 2000 for the viability report, which have either been rejected or not replied to. There was insufficient time for an application to the Information Commissioner's Office in time for this inquiry, and no doubt it can be considered for any future compulsory purchase orders on the West End of the State. As the inquiry is also aware, in London Borough of Southwark versus the Information Commissioner, in the first tier tribunal of the General Regulatory Chamber, I've given the reference there, it was a decision dated 9th of May last year, the decision was that the viability report should be released in full. The facts in Southwark were very similar in that it was an estate regeneration scheme where London Borough of Southwark had entered into a joint venture with Lend-Lease. Though the application refers to non-disclosure following a Freedom of Information request, rather than an order made under Section 226, subsection 1, subsection A of the Town and Country Planning Act 1990, it is the objector's position that the public interest in transparency applies equally. As the inquiry is aware, partly from evidence of Mr Langleburn, the London Borough of Barnet has, in section 8.1 of the Statement of Reasons, stated, "The Council has followed a transparent and objective decision-making process leading up to the decision to exercise compulsory purchase powers." Now, I've quoted the Statement of Reasons where that comes from. Without the release of the viability report for the inquiry and subsequently the Secretary of State to consider, the assertion made by London Borough of Barnet is incorrect. It is also the objector's position that there is sufficient reason to believe that a scheme with a larger percentage of social housing would have been viable. In cross-examination from Mr King, I referred to the differences between the scheme envisaged in 2002 at the time of the pledges and the scheme now before us. Though no planning application was made in 2002, it is reasonable to assume that the developers would have undertaken at least a brief viability study or residual valuation to calculate whether a small increase in the density would be viable with each social rented property being replaced with another. Since then, the developer has changed to a far larger one, who I suggest are likely to have more buying power than the old. The number of social rented properties to be built has more than halved, whilst the number of private sale properties has increased by circa tenfold. In addition, at the very end of the most recent day of this inquiry, other than that devoted to the site inspection, supplementary information was handed out by the promoter confirming that the order is to be transferred, so that the order land is to be transferred for no monetary consideration, making the scheme even more viable. The scheme promoter has suggested that the changes are due to economic circumstances being different. The objectors agree that circumstances are different to those in 2002. The prices in which private sale properties can expect to achieve are now far higher than they were in 2002. The annual increase in house prices in the borough, according to the Land Registry, is however remarkably similar to 2002. Section 6 is consultation. It is the objector's position that the consultation carried out has been insufficient. Residents' expectations of the scheme were largely set in the November 2002 ballot. It has been discussed to a great extent within the inquiry that a number of pledges were made by Metropolitan and London Borough of Barnet that have not been kept. I shall briefly summarise some of the most pertinent pledges which have not been kept. Number one, you will have a brand new home. The promoter has sought to claim this was addressed to individuals on the estate rather than tenants as a collective. A rather spurious suggestion which the objectors contest. Number two, you will have a choice of landlord. Not the case. Number three, you will have a choice of where to move. Not the case, as allocations are all within the block on the gyratory system. Number four, your rents and service charges will be affordable. I've already covered this. I've already covered why the objector's service charges are unaffordable, and also why those who take an affordable rent may, in many cases, not be able to afford it. And number five, you will have a brand new home in West Hendon. I've already covered why shared equity units may not be a viable option, and why many tenants may be unable to afford to remain on the estate. I referenced there the Our Pledge to You document, which is in Appendix 3 to my own proof of evidence. I believe it's also elsewhere in other evidence as well. It is accepted that with a change of developer and change in economic circumstances, some pledges may need to be altered. However, those that have been altered have, in the objector's opinion, left the scheme failing the public interest and well-being tests in the circular. In cross-examination of Mr. Shipway, he suggested that he believes a modern-day ballot with the same question, namely whether residents are in favour of regeneration or not, would come up with the same answer. Whilst impossible to say with any certainty, it is the objector's position that a modern-day ballot would result in a majority against the current regeneration proposals. Mr. Dismall's own survey provided to the inquiry is rather damning evidence to suggest that residents are not in favour. The turnout for this inquiry and number of residents making statements in support of objectors supports a strong feeling that residents are against the proposals as they do not feel they are in the public interest. The protest that has taken place and petition of circa 75,000 people further provides evidence that residents are not in favour of the proposals. In addition to the ballot, the promoter has on a number of occasions referenced the Residents' Regeneration Group, RRG, meetings which are now known as the Partnership Board, PD. However, statements by Father Hawkins, Miss Bates and Miss Parsons have suggested that the RRG have been ineffective, often providing information to consult on with insufficient time for it to be considered. For example, in a penultimate paragraph on page 2 of Father Hawkins' evidence, he states, "The Partnership Board have typically received information about these changes too late to have the opportunity to make a meaningful input. An example of this, information about the Section 106 variation was given to us to look over on 28th October 2014. But we found out that this was a waste of time, as the committee meeting to make a decision about this was on 29th of October 2014. Father Hawkins further refers to the board only having 24 hours notice of the service of Ground 10A letters, and that newsletters are sent to residents with very little consultation. Miss Parsons referred in her statement to the board not being told what happened to the previous development partners, Bellhouse, Joseph and Lavelles. She also refers to the RRG not being consulted on the contracting of E.ON to provide the hot water heating system to the new development, despite previously being told that they would be after London Borough of Barnet failed to inform them about a similar contract for the pilot phase at Skylark Court. There have been a number of exhibitions where residents have felt talked to rather than consulted. The promoter has also suggested that letters regarding the planning application constituted consultation. Given that this inquiry is to assess the order, not the planning permission, I fail to see the relevance. The feedback to the planning application, as we've heard, was 340 objectors and one person who wrote in favour. Given some justified and some unjustified changes to the regeneration scheme and the length of time that residents have waited for it, it is the objector's position that effective consultation is all the more important, but that it has not been provided. Section 7 is attempts to negotiate for consensual transfer of the properties affected. In Mr. Watling's summary statement, section 4.12, he advises that first offers were made on 4th of June 2014. In cross-examination, he confirmed that they were made by post, thereby arriving on doorsteps on 5th of June and 6th of June. The inquiry has also heard that the compulsory purchase order was made on 5th of June 2014, albeit reissued a short time later due to an administrative anomaly. Both Mr. Watling and Mr. King have suggested that the requirements under section 24 of the Circular 06/2004 are for negotiation to take place before the CPO is made. It is the objector's position that the requirement is for a reasonable prospect of acquisition to take place, and this has not been complied with. The relevant excerpts from section 24 is quoted below. Before embarking on compulsory purchase, acquiring authorities should seek to acquire land by negotiation. I've added emphasis by putting the word acquire in bold. Mr. Watling's statements in section 4.11 also advises that hourly fees have been agreed with the majority of surveyors. His statement does not extend to state that caps have been put on those fees around half the level the residents' regeneration group were advised of, see my appendix 1. But for surveyors taking the risk of working without agreement on fees, leaseholders would have been denied proper representation. Section 80, York Memorial Park. It is the objector's position that the park has at some point been granted memorial status, and that alterations to it under the development plan would reduce its usability for local residents. The evidence submitted by Mr. Wild for the promoter and Miss Musgrove for the objectors is contradictory. Given that Miss Musgrove's evidence provides photographs and excerpts from a book written by the Council's archivist on the subject, who I understand supports her evidence, I am inclined to give more weight to the evidence from Miss Musgrove. York Memorial Park is of great importance to the residents of West Hendon and has regularly been referred to both in objector evidence and also in my discussions with residents outside of the inquiry. Miss Parsons' evidence refers to the Localism Act 2011 and the requirements under it to offer important local assets to the community before offering them for sale elsewhere. The Act came into force prior to the appropriation of the land for planning purposes, and as such should have been offered for sale to the residents at public open space value, or, as is the case for the developer, at no monetary consideration. The devastation of the events in 1941, which subsequently led to the park being granted memorial status, are ones clearly not to be forgotten. It is the objector's position that losing some of the existing use of the park and having park built on with a 29-storey skyscraper does not comply with the public interest test in section 17 of Circular 06/2004. Councillor Mashari referred to the risk of the Welsh Harp Reservoir losing its status as a site of special scientific interest. Section 9 is insecure tenants. The promoter has suggested that the large number of insecure tenants should have less rights than those with secure tenancy agreements. It has been contested by a number of insecure tenants whether at the point of taking their tenancies they had a realistic expectation set by Barnet Homes that their tenancies would later convert into secure tenancies. Insecure tenants make up approximately 200 of the households on the estate. Until a number of them were recently evicted, their numbers were higher than those of secure tenants. See Appendix 4 of my own evidence in chief. Their own well-being, to be assessed under Section 6 of Appendix A of Circular 06/2004, appears to have been ill-treated. We have heard Mr Shipway's evidence and cross-examination of Miss Parsons, which referred to insecure tenants being offered one choice of rehousing, while secure tenants are offered 3. We have heard of medical assessments not being carried out, of undue pressure being placed on tenants to move, and of genuine concern of individuals. Ms Miller and Ms Fricker both referred to health risks to young children. Ms Essack referred to a housing assessment hearing being scheduled for the same day as the court appearance to evict her. We have heard from Ms Sandra Newman how many tenants are of the opinion that to swap their views of the Welsh Harp for the back of kebab shops on the gyratory system properties is unsuitable. Mr Finney suggested a continuing theme amongst tenants of hearing very little from Barnet Homes. Mr King has helpfully provided statements of fact as the promoter see them on how individual tenants have been treated. There may be a number of those who have provided statements who have some level of misunderstanding. However, that is part of the issue. A large number of unconnected tenants are suggesting the same things, that they are being treated unfairly and are kept in the dark on a number of issues. The issue in front of the inspector that the objectors would like her to consider is the general approach which is being taken by Barnet Homes. It is the objector's position that if the compulsory purchase order is confirmed, the social and environmental well-being of these tenants, which is to be considered in the well-being test, which I referred to, would not be complied with. In cross-examination of Miss Parsons, Mr King referred to the housing allocations policy and the ability for tenants to appeal if they are unhappy with their treatment. Despite the valuable support provided to many by Miss Parsons, making challenges is unfortunately an unfamiliar and difficult concept to the majority of tenants who may be scared of the process and, given their experiences with Barnet Homes, have little faith that their concerns would be answered. When many of the insecure tenants were granted their tenancies, they assumed they would reside on the estate for a short period of time. Their tenancies were, after all, referred to as temporary. With many of these tenants now having occupied their homes on the estate for 10 years or more, it is the objector's position that they are as much part of the estate as secure tenants are, so should be dealt with in the same manner. The promoter's reluctance to do this, again, does not pass the well-being test or the public interest test. Section 10 is effect on existing estate if the compulsory purchase order is confirmed and the scheme is taken forward. If the scheme progresses, there is potential for the tall buildings to cast shadow and some water next, right? If the scheme progresses, there is the potential for the tall buildings to cast shadow and block light to the existing estate properties. In cross-examination of Mr. Haynes, he explained the study that would mitigate effect on the new build properties, but made no reference to the effect on existing properties, some of which are phased for demolition in 10 years' time from now. Mr. Haynes also advised that the play area would not be provided until at some point during phase 3A, leaving current residents on the estate without play provision for an undeterminable amount of time. The multi-use games area is also being withdrawn, and the ability for use of York Memorial Park is already inhibited. It is the objector's position that this is not in the public interest. In Mr. Wilde's evidence and in cross-examination, the local plan core strategy was referenced. One of the themes within the sustainable community strategy was healthy and independent living. Mr. Wilde confirmed that 7 out of 12 nearby GP surgeries had available spaces, thereby meaning that 5 did not. That's page 82 of core document CPD 34. It is the objector's position that with the increase in density, not only on the West Hendon estate, but also on larger proposed increases in density within a mile or two at Graham Park Estate and the Peel Centre, that GP services will not cope. The same applies with school places, which again is within the sustainable community strategy, listed as investing in young people and their families. In her evidence and cross-examination of Mr. Wilde, Councillor Kay suggested that it is feasible for London Borough of Barnet to not build a new school at the end of the phasing programme if the child yield does not demand it. It is the objector's position that the lack of certainty of provision of a new school, the public interest test, is again being failed. Section 106 funding has been allocated for recruitment, employment and training, with the first £114,140 already allocated for borough-wide uses, with approximately a further £400,000 still to be allocated. It is the objector's position that it is unsatisfactory and not in the public interest that none of this has been allocated specifically to the West Hendon estate, which has been described as an area of deprivation. With the proposed increase in housing density, coupled with nearby increases in similar timescales, there is concern that Hendon railway station will not cope with the additional demand. Mr. Langworth referred in his statement to the station running a shorter platform than other stations, which will restrict the amount of trains it can accommodate. The increase in demand for public transport, combined with a potential reduction in services, has the potential for creating a perfect storm, which could result in more car journeys, which, given the local existing congestion, could be detrimental to the free flow of transport. It is the objector's position that this is not in the public interest and that it could damage the well-being of the local economy. There have been a number of issues raised regarding the impact of construction works. Miss Jackie Parsons, in her statement, refers to 55 hours per week of construction and the effect on her health. Mrs. Walker, in her evidence, referred to the harmful effect of construction workers on her 85-year-old mother's life, limiting health conditions. Councillor Kay gave evidence of complaints that have been raised and how they haven't resulted in permanent change, but instead have resulted in different companies referring complaints to each other. It is the objector's position that if the compulsory purchase order is confirmed, the threat that construction works will have both on those currently suffering from them and those in future phases of regeneration who may suffer from similar issues is unjustified. It is the objector's position that confirming the order would again fail the test for both public interest and well-being. The West Hendon estate is one with a very strong community. Sometimes in the face of adversity, communities pull together, with the spirit they show increasing day by day. The estate is possibly the strongest community spirit that I have known in my experience of compulsory purchase, which revolves largely around housing estates. They have at times laboured points during this inquiry, largely due to the sensitive nature of what is being considered and being unfamiliar with the process. Almost without exception, they have behaved very well at this inquiry, something which I commend them on. Similarly, I have heard nothing but praise for the understanding and tolerant way in which you, Madam, have held the inquiry, which I also commend you. I thank you for also tolerating the length of this statement, which I promise is now almost complete. And lastly, my conclusion. It is the objector's position that regeneration is required on the West Hendon estate. However, it is also the objector's position that the compulsory purchase order, if confirmed, will allow regeneration that is not in the public interest, failing tests under Section 17 and Appendix A, Section 6 of Circular 06/2004. The objectors would welcome further discussions on how regeneration can be achieved on a basis that would comply with the circular. The objectors also believe that given the non-production of the viability report, that the inspector does not have sufficient information to be able to confirm the compulsory purchase order. It is the objector's position that the London Borough of Barnet, West Hendon Regeneration Area, Compulsory Purchase Order Number 1, 2014, should not be confirmed. Thank you.
Thank you. There's just one question I want to ask you from that, and you make reference to the petition. That's not a petition that I've actually seen, although I've heard a lot about, and I wondered what was going to happen.
I've got it here for you. I've got it transferred onto it so you can see it electronically, so it's easy for everybody to see.
I do have a bit of a problem with electronic documents in that I clearly can't see them now and be certain that the same thing is on every disc for every person. What I suggest you do is send that to the office and provide a copy to yourself. We need to work out a way that you're happy that they are the same thing.
Well, I'm sure they will be, but I mean, perhaps we could. Is there a disc? Are there several discs, or are they all on that sort of tablet?
Well, it's just it's a link page. You can link straight into it. So
but if you email us the link page, then someone here will have a look.
Well, if it's a link, we can only look at it on
we can only look
the
at
same thing, which solves some of the problem.
No, I'm quite happy with it, perfectly happy. Just quite like to see it before we finish the inquiry. That's all.
Well, I've got the page out. I've been on the page.
Well, what I suggest is we just have an adjournment now. It's 11 o'clock, so we're going to adjourn until 4:15. Will that give you sufficient time to look at the link? Or
I expect so, yeah.
We'll start back down to 11:15. Just a couple of matters I want to run through before we start, Ms. Parsons. First is to check you're happy with the link.
I don't know. I'm not sure. I didn't personally. All right, just give us a second. I'm sorry. I didn't like that.
Run through a couple of other matters then while you just sort that out.
I'm sure it's fine.
Just so people are clear about yesterday and the site visits, I'll just confirm really that we went to Skylark Court, 17 Tyrrell Way, flat 62 Franklin, and 2 and 4 Marsh Drive. And then we looked generally around the area, including looking specifically at things like the bridge and looking at the commercial properties on Broadway. So you're all clear what happened. In terms of other things we need to sort out, we do have the document handed in from the RRG, which has now been copied, and there's Ms. Parsons' statement to come around to everybody as well. We do that while you have a look for that link.
We've looked at it, it's fine. It's not here. We found it.
So what will happen with the link is it'll go off to my office, it'll get sent through to me. If there's no question about anything on there, that's fair enough. It's simply what's been told that it's a petition. It will be helpful perhaps at least to know what the petition's title is though.
Titled.
Well, if you're happy to do it.
Yeah, it's called Put Our Homes Before Profit. It's a petition to Boris Johnson, the council, Barnet Homes, and who offered it. You get that all.
Can you just confirm for me the inquiry numbers we've given, inquiry document numbers we've given to those?
So we have Mr. Gold's closing statement is 45, the RRG 2005 documents is 46, and Ms. Parsons' statement is 47. Thank you.
Ms. Parsons, when you're ready, make sure you've got some water as well.
Hendon Parsons was my closing statement. Refer to evidence in section 8 by Mr. World and Ms. Masgrove in connection with York Memorial Park. It has been known to London Borough of Barnet for a number of years and has been taken into consideration for a number of years and has been taken into consideration with their viability study, which if produced would clearly show that if the York Memorial Park was left to its full size or increased as was stated in 2005 in the RRG meeting, the scheme would become inviolable. The London Borough of Barnet has had several years to check the status of York Memorial Park, and I strongly believe that they did realise that if it was taken into consideration, they would not be able to push through the planning application. London Borough of Barnet has a history of being found guilty in court for deliberately withholding information and being deliberately misleading. Rosemead was conducted without a CPO order being applied for. In fact, the partners went out their way to avoid a CPO order and held numerous meetings with homeowners to ensure a deal that was acceptable to all parties. Contrary to this latest phase, as the partners seem desperate to ensure that the CPO is put in place to ensure that the scheme, which is reliant on being able to build on York Memorial Park. The proof is clear in the two-line statement and in folder CDB24, Environmental Study, Volume 2 of 2, Appendix 14.1, page 227, Historical Parks and Gardens, which I can't find it in here, so it's just a 2-line statement which makes it clear that there is no historical fact that they could find. Furthermore, it is also clear that if the scheme had not taken off, then the land at London Borough Barnet, gave to the partners at nil cost, would be forfeit, would have to be returned to London Borough Barnet at nil cost. It is also crucial to the viability of this project that the land built scheme decreases further to continue to be able the viability of this scheme, i.e. the red line decreases from private land that needs to be bought at current market value to the public land at nil cost, with buildings rising above agreed heights out of the character of all the surrounding area. All except the high building, except for Frankton House, as all the high buildings, if everybody notices, all sit on the northern edge of the Edgware Road, the A5. Previous planning agreement, 2008, included almost a third extra land in which the building heights would have been much lower. All that land is private and has almost all land is private and has to be purchased at market value. To continue with this scheme, a variation deed was needed to be incorporated to ensure that new changes to the planning as it progresses can be put through without having to take into account the views of the residents. This only increases the view that more social homes will have to be removed from the now current scheme. Martin Cowell, in his statement 6.2, stated it is clear that private treaties have not yet been carried out by Capita, with maybe one or two exceptions, prior to the CPO being applied for. As we already know, it was actually delayed by 3 weeks. So had the original application not been stopped, the CPO application would have been applied for 3 weeks before the first blanket proposal letter landed on a homeowner's letterbox. 6.10 on the same page of Martin Cowell. This is his summary statement. I do apologise. I will merely state that as a London Borough of Barnet consider that regeneration sites are suitable accommodation for all the tenants which they are encounting, they should be listed in their housing allocations scheme in September 2013 as such. Dan Knowles has pointed out in his closing statement, page 12, third paragraph, about the S106. I would just like to clarify that the Barnet officer stated that the planning department did not have to inform the residents, us included on the RRG/partnership board. The reason being that the decision had been made, even though the decision had already been made, even though the council had this information 4 to 6 weeks previous, and they do not need to inform the residents. I would have said more, but I finished with that. But I would like to say thank you to you, Mrs. Zoe Hill, for, I believe you've done a spiffing job. And again to Mr. Neil King, QC, who's also been integral with his position. I would like to comment that during some of these statements that have been made, it has been unfortunate that certain members on the council side have either sat there and played with their mobile phones during which people was giving evidence, fallen asleep while people were giving evidence, and some have actually found some of the statements which the residents was making quite humorous. And I found that very, very, very offensive to all the residents. I have my statement there. Thank you.
Thank you. Mr. King.
Thank you. Can we have the submissions distributed, please?
I have 2 copies of all possible.
So you have a second copy of this license.
Thank you. And next IMQ 48.
It's lengthy, this, but it does contain some material from our opening and also some quite lengthy quotations, which I won't read, so it won't be quite as bad as it looks. There are a few things that I will need to add in response to what Mr. Knowles and Mr. Ms. Parsons has just said. I will try to do those at the right moment in my submissions. So that you can take a note, but I will make sure in the end that everything is covered, about 5 or 6 extra points.
I would say, I suggest we work through, and it may well mean we work through parts from the plot. So
this is going to take a lot more than an hour, I'm afraid.
I guess, yeah. I just want to make sure everybody in the audience is aware of that. My intention is to hear you in one go and start.
Okay, all right, we'll be here till 2. It's going to take 2 hours.
No, that's fine.
Okay. I might ask for a break at some point myself, but I'll probably be fine. Now, Madam, just by way of introduction, it's quite short, the introduction. If you've cast an eye over the first page, you'll see something that's quite familiar because this is really taken from our opening statement. What we've tried to do is present as a comprehensive version of our case rather than saying attack the opening and the closing together, although the opening we do still rely on the opening. I don't know that that's been sent electronically, but we will do that as well as the closing. But I won't read paragraphs 1 to 4 because it's background that everyone's very familiar with. I'll pick it up at paragraph 5. The scheme benefits from having had planning permission already granted. The funding required is available, although some matters remain to be addressed, including reserved matters approvals and some further high-rise orders. There are no substantial impediments to the implementation of the scheme should the Secretary of State confirm the order. The only outstanding impediment, therefore, is the completion of land assembly. Just forgive me for one moment. I'm just checking on something. I'm sorry to stop so early on. So what we do in the closing, paragraph 6, is to summarise the features of the scheme. We set out the legal framework for the making confirmation of the order, then we address the evidence, as it were, against the relevant provisions of the circular. And we got those 12 headings, which I won't read out because we'll come to them as we go along. So, general approach. We think it necessary first, before getting into the detail, to say something about the nature of the objections that have been made to the order and how these fit in with the approach that the Inspector and Secretary of State should take to your respective recommendation and decision as to whether the order should be confirmed. The basis of the power to make a planning compulsory purchase order under the first limb of section 226 subsection 1 is entirely clear. It is to facilitate development, redevelopment or improvement, see further below under legal framework, provided the authority thinks that there will be well-being benefits section 2261A. Similarly, the policy basis is clear from the circular and is long established. This includes consideration of the planning framework for the scheme in question and the need to show a compelling case in the public interest. The case for the CPO must be, for a CPO, any CPO, must be judged by reference to current policy and legislation. This includes not just planning, but also housing policy, in this case such as the Council's housing strategy and statute. It is necessary to make this obvious point, which we previously made in our opening, because in this case much of the substance of the objections, in particular but by no means exclusively from politicians such as Mr Dismore and Councillors Langle, Ben and Kay, are political in nature. That is, they stem from a disagreement with current policies and indeed legislation relating to how housing provision, including affordable housing provision, is to be made, what regeneration should mean, and at a more detailed level, how occupiers of council and other affordable housing accommodation should be treated in cases where a regeneration project requires them to move from their existing accommodation. Just by way of an aside, I'm going to make a note of this. It's not a criticism, it's an observation on the nature of the objections that have been made. It is obviously possible that under a difficult political regime, a different type of regeneration scheme would have emerged as compared with that which has the benefit of the 2013 permissions. But such speculation is pointless, indeed wrong. The Council decided when it granted the 2013 permission that the balance of public interest lay in favour of the grant of planning permission. That does not mean that there is necessarily a compelling case in the public interest to make and confirm the order. We deal with that question at some length in a moment. But unless it can be shown that the circular text, or more accurately factors, are not met, the order should be confirmed. Many of the objections, Mr Dismore again, Councillor Mashari from Brent, repeat objections made to the planning application. These objections we submit were all comprehensively and fairly considered, not only by Barnet Council but also by the GLA as part of their respective assessments of the application. Complaints are made about the procedures adopted and the inadequacy of officers' assessment of the issues raised, but the fact is that no legal challenge was made to the grant of the 2013 permission, and neither the Mayor of London, who declined to exercise his calling power, nor the elected members of Barnet Council agreed that the officer's analysis was flawed. It's also relevant to bear in mind that many existing West Hendon tenants have already moved to units in the pilot and lakeside phases of the scheme, which Madam you would have seen yesterday, and more are to move, of course, to phase 3A, the delivery of which is not dependent on the outcome of this inquiry. There is no evidence that any of the residents who have already moved are dissatisfied with their new circumstances. Now, the consistent theme of a number of the objections has been that residents' views have been ignored. This is not true. The 2002 ballot was not repeated because there was no need, nor any legal obligation to do so, but residents have been given every opportunity to make their views known during the planning process relating to the 2013 permission and by way of objection to this order. The facts are set out, and we urge you to stick with the facts, are set out in the evidence of Martin Cowie, in the statement of community involvement that was submitted with the planning application, and in the officer's report on the application. And in relation to the officer's report, Madam, we invite you to note that as paragraph 4.2 says of that document, the issues raised in the objections were also covered in the planning appraisal section of the report. And any fair conclusion would be in our submission that people were able to make their views known and have them taken into account. So what we say about this material is that this is plain. First, the pre-application consultation is extensive and afforded every opportunity for residents to see what's proposed and to comment on this. Second, those comments, that is the comments that were made, were set out in the Statement of Community Involvement and were taken into account in finalising the master plan. Third, interested parties would have known about the application. Fourth, they had every opportunity to comment on it and did so. And fifth, the issues raised were comprehensively addressed in the officer's report. The text is shot through with document references. I won't read those out. Mr. Knowles has said in his evidence that only a very small number of residents appear to have actively taken part in consultation events over the last few years. The facts are that 70 people, of whom 50 were estate residents, attended the March 2012 consultation event, and around 180 attended the December 2012 public exhibition. This may or may not be a small number in the context of the estate as a whole, but there can be no doubt that residents had the opportunity to inform themselves about what was proposed and make their views known on it. Much of the residents' evidence has comprised complaints about the way in which they have been treated by Barnet homes in terms of information provided, failure to recognise their particular needs, and even bullying and harassment. These allegations are simply not accepted, and a response has been given in the evidence of Paul Shipway and in that inquiry document number 44. Clearly, Madam, these are not matters that can or need to be resolved by you, since there are procedures in place to do that, pursuing complaint through review and appeal, defending court proceedings, and taking the matter to the local government ombudsman, as has been done in one case. But more broadly, however, it's important, we think, to appreciate that the actions taken by the Council in relation to both secure and non-secure tenants have been done in accordance with the law and in accordance with the Council's West Hendon residential decant strategy, the West Hendon Regeneration Secure Tenants Moving Pack, and the Housing Allocation Scheme. These documents themselves set out protocols and other information which are entirely consistent with the Council's legal obligations, and it has not been suggested otherwise. It is, of course, very difficult not to sympathise. Indeed, it's impossible not to sympathise with the circumstances in which some of the residents, particularly those with debilitating and sometimes serious medical conditions, find themselves. Most people, we observe, however, whether or not they are unwell, will not want to be forced to move homes, whether because of a compulsory acquisition process or because it is forced on them by some other change in their personal circumstances. But even so, it must be noted that many of the existing residents have not objected to the order. But the question is whether forced acquisition in this case, of course, is justified in the public interest. One always returns to that question. And in that respect, and setting aside, if I may, for a moment, the wider regeneration benefits of the scheme, in the particular cases of those who have spoken at the inquiry, the Council is meeting and will continue to meet its obligations. Those who are owner-occupiers and secure tenants will have the opportunity of moving into very attractive new homes on the estate. Non-secure tenants will be rehoused in the light of housing need assessments in all likelihood elsewhere in the borough and otherwise close to it. In the case of the non-secure tenants, it's been the Council's practice over the last 10 to 12 years to move those in housing need to the West Hendon estate temporarily when properties have become vacant. This practice has not itself been the subject of criticism and has constituted, we think, an appropriate and sensible use of resources. The regeneration project has, however, encountered significant delays for reasons which have been explained in the evidence, in short, physical and financial deliverability, which has meant that those who were moved to the estate on a temporary basis are being moved out of their accommodation considerably later than had originally been anticipated. I think everyone agrees that that's very unfortunate. But, madam, these circumstances provide no basis whatever for finding that the non-secure tenants should now be allowed to stay where they are for the foreseeable future, and we address the position of tenants on the estate in more detail below. So, section 2, the scheme. Much of this we said in opening. I can probably summarise much of this. The developers are a consortium of Metropolitan and Barnet. We refer to who they are in that paragraph 22, and Barnet London in particular have very extensive and relevant experience of regeneration projects, and we cite paragraph 310 of Mr. Caladine's evidence, which obviously we draw attention to. I'll turn to subsection 2, the order lands. We describe them in opening, the information is there, I won't read that out. I think I'm inclined to take 24 and 25 as read, if I may. You've had that before. 26, we refer back to Virginia Blackman's evidence. Only such land and rights as are necessary for the delivery of the scheme have been included in the order. For example, Ramsey Close now has been excluded, and that remains the position at the end of the inquiry. Features of the scheme. The order will facilitate the completion of Phase 3, which is intended to catalyse the regeneration of the West Hendon area. See the design and access statement and Mr. Haynes' proof of evidence. 2,000 new homes, linkages through to the West Hendon Broadway, there's a typo in Welshart Reservoir, new education and community facilities as well as retail and commercial space, landscaping, phasing to enable the decanting process to take place and highways improvement. Mr. Haynes' evidence, again, we refer to in paragraph 28. He explains how phasing has been carefully considered, the importance and value of improving the entrance to the estate, the way in which the streets have been planned with improved legibility in mind, the coherent arrangement of the public open spaces, and the design which is appropriate for its setting. Legislative and policy background, section 226 we've set out in paragraph 29, I won't read that out. Paragraph 30, the compulsory acquisition will facilitate the redevelopment of the order land, 2261 little a, and redevelopment site to contribute to well-being. Objectives 2261 capital A, and we are inviting the Secretary of State to confirm the order on that basis. Acquisition of Land Act has publicity and notice requirements which have been met. In paragraph 33, we recite the modifications which we're asking the Secretary of State to make to the order in the light of the withdrawal of the Canal and River Trust. Objection, you know enough about that for me not to have to read all this out in closing. We do have a deal in paragraph 34 with a particular point that Mr. Knowles made during the course of his evidence, albeit not, I think, in his closing submissions, because he has said in his evidence, I shouldn't say during, by, obviously. I mean, our intention, if I may just interrupt myself for a moment, if we pick up typos going through, we're going to send you a corrected version. But there'll only be things that I've picked up as I've gone through. It should obviously say it was alleged by Dan Knowles the interest in Table 2 having been identified with sufficient specificity. That objection we submit is groundless. The proper form of compulsory purchase orders is prescribed in the relevant regulations. All of the schedule in the prescribed forms regulations requires to be included consistently with the statutory language in section 12(2) capital A of the Acquisition of Land Act is a description of the interest which may give rise to a claim for injurious affection under section 10. The level of detail in the order plainly meets that requirement. That is, rights of access or rights of light for the benefit of, and the property is identified. That approach is generally accepted practice and is perhaps all the more appropriate in this case, given that, as Mr. Watling has confirmed, alternative access will be maintained to all remaining properties throughout the construction works and thereafter. And secondly, as is commonly the case, details relevant to if and how Table 2 rights will be engaged remain to be confirmed through the reserved matters stages. Madam, to require the nature of the right that may be affected and the exact extent of the land to which it relates to be specified in more detail is in our submission therefore both unnecessary as a matter of law and actually impractical. Section 13(1) of the Local Government Miscellaneous Provisions Act 1976, that's to do with the acquisition of new rights, and I won't read that out, I'll cover that in opening. The circular, paragraphs 17 and 19, we set out in our submissions, including, of course, the famous phrase, compelling case in the public interest, and reference to relevant provisions of the European Convention on Human Rights. There must be clear evidence that the public benefit outweighs the private loss, and that's the basis on which the order is being promoted. Then we cite paragraph 16 of the Appendix A to the circular with the 4 factors. I won't read those out. And in paragraph 40, having transposes from the opening, it should say that the compelling case of public interest which justifies the making confirmation of the CBA is set out in the evidence presented, not to be presented, because we've done that, by the promoter's witnesses in the core documents. In summary, in relation to paragraph 16 factors, we are saying that the scheme is compliant with the planning framework. There will be contribution to the promotion and improvement of economic, social and environmental well-being. The developer, without doubt, has the resources, experience and incentives to deliver the scheme. And the 4th factor, which is whether there are any other means of achieving the purpose, the need to regenerate its ageing housing estates has for many years been and remains a key component of the Council's housing strategy. There are no reasonable alternatives to the scheme which would achieve the requisite planning and regeneration objectives, and none is seriously suggested. So, before I move on, Mr. Simon's going to tell me something. Okay. Okay, that's brilliant. Thank you. There was something that we need to check. There was something we needed to check that I overlooked this morning, and we're going to hand you a replacement page in a moment. But that comes later in the submission, so we can continue for the time being. So, turning section 4 of our submissions is paragraph 16(1), fact in Appendix A of the circular. The question is whether the purpose for which the orderlands are being acquired fits in with the adopted planning framework for the area. The promoter's submission is simple. Not only does the purpose fit with the framework or fit in with it, it is central to the framework's delivery. What is the adopted planning framework? It's the SPG, the Development Framework SPG, it's Safe Policies of the Council's Unitary Development Plan, and it's the Local Plan Core Strategy. Development Framework SPG, published jointly by the Council and the Mayor of London, adopted by the Mayor as an opportunity area planning framework, and it starts with these words: the London Borough of Barnet, the Greater London Council identified the Cricklewood, Brent Cross and West Hendon areas as a major opportunity for regeneration of borough over the next 20 years. This was 2005. The strategic principles include, with this framework document, in the region of 10,000 new homes, a commitment to the provision of affordable housing and places of local employment for the existing and new communities, improvements or additions to existing community facilities as part of the creation of a sustainable community, the provision of new public open space, enhancement of the existing green spaces and links to established neighbourhoods, fully accessible street network that positively encourages the use of public transport, walking and cycling over the car, and a comprehensive approach to regeneration that embraces implementation on both sides of the North Circular. Page 36, the vision for West Hendon. I'll summarise this. It's there in the text. 2,200 units of housing approximately. So far as affordable housing and West Hendon is concerned, if existing housing must be replaced by an equivalent amount, type and mix funded by the private sector in order to meet decent home standard. Density is likely to be increased. Then we turn to the Unitary Development Plan. We cite policy G-CRIC. I won't read that out. We cite the introductory text policy C1A, which is specific to West Hendon, and that citation goes on for about a page. And I won't read all that out. You will be aware of at least what it says. But the emphasis, in short, in it is on the need for comprehensive regeneration of the West Hendon estate. We then cite policy C1A itself, and West Hendon is given priority in the supporting text and in the policy. It refers to development of high-density housing at the highest design quality to replace existing stock with a mix of housing, and other matters which I don't need to read out. The core strategy, it's in the text. The core strategy, thirdly, regeneration of West Hendon, the core strategy is referred to as a central part of Barnet's future, a major priority and core objective. And the core strategy summarises the proposals for West Hendon. We give the paragraph reference. It's a major priority to regenerate failed housing estates in Barnet, including West Hendon, amongst others. Long-term programmes of regeneration are proposed in order to tackle poor quality housing, social isolation, and transform those areas into successful mixed tenure places. West Hendon specifically, what's expected is there set out, and I won't read that out. We refer also to policy CS1, which is a borough-wide regeneration strategy, CS3, which refers to the distribution of housing growth. Again, I won't read that out. West Hendon is mentioned in that policy, and it has a projected timescale phasing for the delivery of new homes on the West Hendon estate. So, by way of conclusion on the planning framework, substantial accord with national, regional, local planning policy was confirmed through the Council's consideration of the 2013 planning application. The planning permission wasn't the subject of legal challenge, and therefore there is no planning impediment to its delivery. Mr. Wilde's evidence made plain the following: the scheme complies with the core strategy's identification of the West Hendon estate as a priority estate, where regeneration involving housing will be expected, not housing. That's the same statement made in the opening. Secondly, that the UDP's allocation of the order lands for regeneration development, I'm sorry, I read that badly. Mr. Wilde's evidence made plain the UDP's allocation of the order lands for regeneration development. Second, his evidence has made plain that the scheme's affordable housing provision complies with the London plan and the core strategy, see further below. And third, the scheme's design meets the core strategy's requirements to create high quality places and a series of core strategy policies in relation to open space, biodiversity, climate change, retail, transport and social infrastructure. Therefore, Madam, the purpose of the order being to deliver the scheme and the regeneration project not only fits with the adopted planning framework, but is a key strategic element of it. So that's the first, paragraph 16, factor. The second is contribution to well-being. And we submit that the scheme will contribute very significantly to the social, economic and environmental well-being of the area, and its contributions will be many and various. We start off by saying something about the current condition of the order lands, which is, we think, the starting point. The position is summarised in Mr. Cowie's evidence. The estate comprises 1960s residential blocks built using the large panel system of concrete construction. Discredited, perhaps, would be an appropriate word to apply to that. The estate suffers from a series of problems, including poor insulation, poor access, poor thermal performance, inadequate lighting, poor security measures, and management problems. In some, the existing buildings provide poor quality living accommodation for residents, and the layout of the estate as a whole is unsatisfactory. And that position has been consistently recognised since at least the year 2000 in the Council's housing strategies. So, the 2000-2003 housing strategy noted unequivocal evidence of the close association between the highest deprivation levels in Barnet and our largest social housing estates. The strategy noted proposals to regenerate the West Hendon estate, and particularly to develop balanced communities by diversifying tenure mix and to break down the barriers that currently exist between these large estates and surrounding communities. The 2001 housing strategy noted that the key strategic housing challenge for the next 5 years is the regeneration of the borough's most deprived neighbourhoods, particularly our priority estates, of which of course West Hendon is one. Major regeneration is said to be the Council's first most challenging priority. The 2002-2005 housing strategy maintained that position, noting that the regeneration programme is the Council's first priority. As to West Hendon, the strategy noted that West Hendon is a unique area with rich potential for comprehensive regeneration, and that this remains the most exciting of the 4 priority estates. The 2003-2010 housing strategy updated the position on West Hendon, noting that a major consultation with residents had been completed and a successful resident test of opinion on the proposal. That, of course, was the ballot. The 2010-25 housing strategy states at page 7, our estate regeneration schemes will see the dismantling of our largest mono-tenure council estate, which should prove to be unpopular and limiting in terms of opportunities for residents living on them. These famed post-war estates, including West Hendon, will be replaced by mixed tenure estates with new social housing, but also opportunities for entry-level and market home ownership. The strategy's targets include the completion of the regeneration of West Hendon estate by 2026. And finally, the draft housing strategy 2015-2020 is currently out of consultation, and it refers, perhaps I won't read all this out, to the regeneration of Barnet's biggest estates by the replacement of 3,000 council homes with 7,000 mixed tenure homes. And we recognise regeneration can be a disruptive process for residents, particularly those that are living in non-secure accommodation, and will seek to minimise this disruption at the point that tenants are required to move by making use of flexibilities within our allocation scheme and providing advice and support. We had further evidence on the poor condition of the estate. Mr. Bakari, his evidence was it's like it's falling apart. Mr. Dismal expressed concern about the poor condition of the estate that the estate has fallen into, and noted overwhelming support for its improvement. So regeneration, we submit and bring out about a wide variety of wellbeing benefits, and we're going to now deal with those. First, social benefits, and we deal under this heading with affordable housing. London Plan Policy 3.14. Loss of housing, including affordable housing, should be resisted unless the housing is replaced with existing or higher densities with at least equivalent floor space. The comparison between the estate's existing affordable housing provision and that proposed in the scheme is set out in detailed accommodation schedules, and we summarise it in that table, which I'm sure I'll be forgiven for not reading out, but that is the current position. What the table does is say how many existing dwellings in each category there are, what the floor space is, the percentage of floor space is, and what's proposed, again in terms of amount of floor space numbers and percentage. The Section 106 agreement sets a minimum proportion of social rented housing at 43% of the scheme's overall affordable provision. Councillor Langway suggested that was insufficient. He strongly suggested that it was insufficient, but, Madam, in determining the social wellbeing benefits which will be delivered by the scheme, the percentage is really irrelevant. The scheme will deliver more homes and more affordable homes than currently exist on the site. The figures in the table are in addition, Madam, to the 43 social rented units which have already been provided in the pilot and lakeside phases. Now, the Council's officer, Mr. Wilde, noted on page 50 of his report on the planning application that the failure to meet the general core strategy 40% target for affordable housing was justified, taking account of the wider regeneration benefits afforded by the scheme, and in consequence he found that it was considered that the proposed mix is responsive to the needs of existing tenants that will be rehoused as part of the regeneration and will assist in making the proposed redevelopment attractive to people who wish to come and live in the area. The GLA in their Phase 1 report considered that the approach is acceptable, subject to viability testing, given the characteristics of the area. The proposals are therefore considered to be compliant with policy context. In addition, the Section 106 agreement includes an affordable housing review mechanism which has to be initiated before any reserve matters application is made in respect of each scheme, each of scheme phases 4, 5 and 6. The developer has to submit an updated, that should be financial appraisal, and to pay for an independent expert to assess this on the Council's behalf. The mechanism includes a dispute resolution procedure. If it's agreed or determined that it would be financially viable to do so, then the developer must, at the Council's election, either provide additional affordable housing units in the scheme or make an additional financial contribution towards the provision of affordable housing elsewhere in the borough. And Madam, if I may add, just by way of a brief aside, Mr. Knowles's submissions didn't refer to the affordable housing review mechanism at all, I don't think, and I don't criticise him for that, but it is important that you and the Secretary of State appreciate, as obviously you do, that this mechanism is included in the Section 106 agreement, and as we'll point out later on, that such a mechanism was notably absent in the case of the Tottenham compulsory purchase order. I'll come back to that in due course. So, Madam, in sum, the number of affordable units is proposed to increase from 453 to 506, with a corresponding increase in affordable floor space of around 8,000 square metres. And what did the GLA's officer say about this? Paragraph 34. The housing officer was broadly supported at the consultation stage, given there's no net loss of affordable housing. It's been confirmed as valid by an independent valuer appointed by the Council. This approach is therefore consistent with London Plan Policy 314. The housing offer will provide an overall uplift in affordable housing, floor space, and an improved mix between market, affordable rent at target rents and intermediate tenures. The provision of affordable rent at target rent level, i.e. social rent in this instance, is acceptable given the requirement of existing secure tenants that require rehousing within the estate. So can I just add two points. One is that Mr. Knowles said in his submissions on page 8, in the second full paragraph, that without independent assessment of the viability, it is impossible to know whether a scheme with a larger portion of social and affordable housing could have been provided. A scheme which may satisfy the requirements of the circular. Well, we won't comment on that last point. But, I mean, there was an independent assessment of viability at the time of the planning application. So, as a matter of fact, that's an incorrect submission. Secondly, in relation to Mr. Knowles's remarks on page 3 of his submissions about affordable rent and whether the so-called affordable rent will, in fact, be affordable, may I ask you to note, please, inquiry document 44, page 5, which is in response, evidence in response to one of the matters raised by Councillor Dr. Kay. Existing tenants was the evidence to which this is a response. Existing tenants will face an increase in rent as they'll be paying affordable rent up to 80% of market rent. This is inaccurate. Rents payable by existing secure tenants who move to a new property will be based on target rents as per the following comparison. There's a little table. So obviously it's for you to take a view on that, but that is the evidence to which we draw attention in relation to that particular matter. So having done that, I will have to come back to the viability issue later on in the context of the requests that have been made and some of the comments that have been made this morning. I'll return to paragraph 72 of our submissions. There was therefore consensus between the Council and the GLA that the scheme's affordable housing provision is policy compliant. It's a matter of fact that the scheme will result in a net increase in both the number of affordable units and the amount of affordable floor space. The Section 106 agreement has this affordable housing review mechanism. Finally, Madam, on this topic, the proper assessment of the scheme's affordable housing provision is not only quantitative but also qualitative. Mr. Haynes' evidence in chief. The sizes of the affordable units in the scheme exceed general London standards. The units will be built sustainably in a way that's more simple to maintain. In his words, they're incredibly well insulated and designed to keep future costs down. In sum, taken together with the environmental improvements which we detail in a moment, the scheme not only adds to the quantity of affordable housing provision on the estate, it also significantly improves the quality of affordable housing provision. Shared equity. One way in which the promoters are providing affordable units is through the provision of a shared equity product to eligible leaseholders. The purpose of the offer was summarised by Mr. Calladine in his rebuttal evidence. The shared equity offer to eligible non-leaseholders has been formulated by the Council and developed in addition to their statutory compensation entitlement. It's an important part of our rehousing strategy and addresses concerns regarding retention of the existing community on the estate. So that's the purpose of it. To participate in the scheme, leaseholders must purchase a minimum of 50% of the new property and must invest all of the market value and home loss elements of their compensation entitlement, even if that exceeds 50% of the value of the property. They must also have acquired their leasehold interest before the 30th of September 2003, Madam, by which time, principally as a result of the ballot and the material associated with it, all estate residents would have been aware of the regeneration proposals. Madam, you asked whether it was registered as a local land charter or anything of that kind. It was not. It wouldn't have been. There was no requirement to do so. Further details on the shared equity product have been provided during the course of the inquiry. We've got this eligibility assessment chart on the very last page of that inquiry document, which shows that for a typical unit in good condition with no outstanding charges, the sum of market value, the home loss payment and goodwill payment will enable all leaseholders to achieve the requisite 50% equity share in a new unit, including for two-bed properties, and if they want it, shared ownership of a car parking space. That's not on offer for the one-bed properties. The offering also includes reimbursing the cost of the electrical rising main works. In addition, the offer now includes a cap, that's in inquiry document 16 and in the chart, on the price for the shared equity properties to ensure that on capital's assessment of market value and with the home loss and goodwill payments, the 50% criteria can be met. Now, that deal, if I can call it that, remains open for acceptance until the 27th of February. And we submit that overall the offer is an entirely reasonable one and cannot be expected to remain open indefinitely as the market is constantly changing and the developer has to know how many shared equity properties it needs to set aside in Phase 3A. For those who do not accept the offer, the dispute about the correct open market of the lease value of the leasehold properties on the estate, and that can be the only reason for not accepting it. That dispute may well be resolved over the ensuing months. If it is not, there is a statutory dispute resolution procedure, namely reference to the upper tribunal, which will ensure that fair compensation is awarded. That is how these things are dealt with in this country, according to the law. The suggestion by Councillor Langle then that the shared equity product doesn't provide truly affordable housing is, we would suggest, entirely misconceived. Shared ownership is particularly picked out as an example of intermediate housing in the framework and the core strategy and in the 106 agreement. The London Plan strongly encourages the increase in provision of intermediate housing as part of a more balanced mix of tenures. The GLA Stage 2 report was right, Madam, that the scheme provides an improved mix of affordable housing when judged against current adopted policy. In short, the level and mix of affordable housing provision, including shared equity products, was considered fully by the Council and the GLA and was found to comply with local, London-wide and national policy. In addition, the evidence demonstrates that should the current offers be accepted, the shared equity product will be achievable for the substantial majority of eligible leaseholders. That's not the best word, is it? Affordable, or perhaps affordable would be better, but you understand the point that we're making. Deal with density. Just give me a moment. I just want to make sure I'm dealing with these points as we go along. Right, density. See the officer's report. The scheme's proposed net density is marginally above the upper threshold set in the London Plan. However, the considerations set out in the officer's report support the proposed density, the creation of a more integrated and legible environment, the daylight sunlight assessment, see further below, which concluded that all units will have sufficient levels of light with limited overshadowing, the scheme's significant proportion of and links to high quality amenity space, the support for 2,000 units in the policies of the core strategy. That conclusion was supported by officers of the GLA who noted that the scheme's density remains above the guidance in the London Plan. However, officers remain satisfied that the setting and design quality allow for this level of intensity of use for this site. Service charge subsidy. The exact details of how that service charge subsidy for shared equity leaseholders will operate have not been completely finalised. The position has been clarified during the course of the inquiry. That document explains that the subsidy is likely to reduce service charges by 28 to 30% for occupiers of the estate for the first 5 years of occupation. Thus, the maximum, that is, occupiers of affordable housing. Thus, the maximum service charge payable by a one-bedroom property will be £13.80 and the maximum for a two-bed property will be £1,780. These, Madam, are in line with other comparable affordable properties in the borough. Now, the pledge. We spent a lot of time on the pledge, understandably perhaps. Mr. Carrick said, when he was asking questions of Mr. Carrick, if the pledges hadn't changed, none of us, the objectors, would be in this room. We think that position is a little surprising because, as Mr. Carrick explained, in relation to the secure tenants, leaseholders and freeholders covered by the document, the 29 commitments listed in Mr. Carrick's evidence in paragraph 230 are still being met. Those commitments are too many to list in these submissions, quite unnecessary to do so, but they include statements that all residents will have a new home in West Hendon, tenants will be provided with a home which has the same number of bedrooms or more as the household is currently overcrowded, long leaseholders will have the option of purchasing a shared equity property if they meet the eligibility criteria, and residents will be compensated for the cost of their move. Now, what isn't being met? Mr. Carey's 237. 4 pledges cannot any longer be met. What are the reasons? First, Ramsey Close residents are no longer being offered units in the regenerated estate because Ramsey Close has been excluded from the scheme as requested by the resident regeneration group. Second, residents can no longer be guaranteed either a move within 5 years of the first unit being complete or rehousing on a floor no higher than their current home because of changed economic circumstances, and decanting issues with the approved scheme, which required the scheme content and layout to be reviewed and altered in order to ensure that it was deliverable. These changes were incorporated into the planning application that led to the grant of the 2013 Planning Commission. Almost all, this is the fourth pledge that isn't being met, although almost all eligible residents will be offered options which allow them to move only once, a number of residents have requested a double move in order to secure a particular property. Now, as a matter, we observe that as the evidence developed, it appeared that the central dispute over the pledge related not really to whether it was being met, but to whom it had been directed. The pledge itself said that existing resident, this is the point that Mr. Knowles describes as spurious, which I think, Madam, you'll find is unjustified. The pledge itself said that existing resident council tenants and owner-occupiers on the estate will be offered a home in the new West End, and that's what it says. It is quite obvious, Madam, that this was directed, as it said, existing tenants, etc. That is, that those who were living on the estate at the time the pledge was made. That's what you'd expect. Any other interpretation with respect to Yasmin Parsons, who will herself be eligible for shared equity property as the scheme proceeds, is willfully misleading in our submission. Mr. Cowie said under cross-examination by Councillor Kay, the pledge was based on those living on the estate at the time. It related to secure tenancy. It hasn't fundamentally changed. Most commitments are still being met, and we submit that that is perfectly correct. Madam, it's a fact that when the pledge was published in 2002, and according to the Council's records, there were no non-secure tenants on the estate. Mr. Dismore said the pledge should apply to both secure and non-secure tenants. Others have said that as well, of course. His basis for saying so was that it makes no distinction between different types of tenure. That was based on his ignorance of the factual position. He thought that he estimated that there would have been around 100 non-secure tenants at the time of the pledge. That's just not right. Mr. Shipway's evidence in cross-examination, the non-secureds have never had prospect of having rehousing on the estate. That was always made clear when they're placed there. It's always been the Council's position that the pledge didn't apply to non-secures. It's also, Madam, relevant to note that the pledge made it clear that option 2, to swap your existing home for a new home on West Hendon, which is the headline point that objectors have continually relied on, was subject expressly and explicitly to the proviso that owner-occupiers must be able to put up 50% of the equity. Madam, in sum, the position remains, therefore, that most of the pledges are being met. It is not surprising that the drastic and unforeseen economic downturn of the late 2000s meant that the content of the scheme had to be reviewed and changes had to be made to it. The Council found that the revised scheme was substantially policy compliant and that it still brought major regeneration benefits. There's a strong public interest in enabling it through the use of compulsory powers to proceed to completion. The decant strategy. Mr. Shipway's evidence...
Can I just stop you there? Obviously, Ms. Foss is upset and has left. I know it makes no difference to your submissions, and your submissions will be here. Can I suggest we just have 5 minutes?
Yes, of course. I'm so sorry. I haven't realised.
If she'd like to come back in.
Yes, of course. Thank you, Madam.
So we'll just adjourn for 5 minutes, which just takes us to 5 to 1.
Right, decant strategy, Madam. Paragraph 88, top of page 25. Mr. Shipway has explained that the residential decant strategy provides these things. The developer will rehouse, as is already rehousing secure tenants living on the estate in a single move to a property with the same number of bedrooms as their existing property, or more if their housing need requires. That move will be taken account of, will take account of. Sorry, that should read, will take account of tenants' personal circumstances and express preference in accordance with the protocol which has been produced with the RRG. Non-secure tenants will, so long as they meet the criteria in the housing allocation scheme, be offered rehousing by the Council generally within the borough. as we previously mentioned, there's a variety of mechanisms open to dissatisfied non-secure tenants who feel their needs are not being adequately met, including the appeals and review procedure, which is in the housing allocation scheme, going to the Ombudsman and, where appropriate, defending possession proceedings. There was an update to the decanting process through an inquiry document Mr. Shipley prepared, and we think the figures are quite telling. As to the 74 secure tenants, 67 already accept the offer of a new home on the estate, 65 of whom will move with no interim temporary accommodation. 3 have refused offers of a new home on the estate, 2 on medical grounds, 1 a tenant who simply failed to engage with the council. 1's been rehoused in phase 2A of the regeneration scheme, 3 have moved away. The 86 non-secure tenants affected by the order, 54 have already been rehoused on average. I think it's 3.2 miles from the estate, all but 1 within the borough. The 1 has gone to the neighbouring borough of Harrow. 35 of those have taken a secure tenancy. 12 cases have been cancelled following discharge of the council's statutory homelessness duty. 10 have been assessed. 4 of those have offers of accommodation pending. I'm sorry, these are of the remaining ones. Obviously, 10 have been assessed, 4 have offers of accommodation pending, 10 haven't yet been assessed, 5 haven't engaged with the council, the others are having a change of circumstances investigated or are subject to eviction proceedings due to rent arrears. There's been a considerable amount of criticism of the council for not issuing further secure tenancies on the estate after 2002. However, that was a deliberate and we suggest entirely justified position for the council to take, as we've already briefly said. From 2003, I'm sorry, it's a bit repetitive, the council's general practice has been not to grant new secure tenancies on its regeneration estates, but has granted non-secure tenancies to those in housing need, so as to make best use of vacant properties. That course of action has had several benefits, which include the avoidance of large numbers of empty units on the estate and any consequential adverse impacts on the vitality of its communal life. That benefit has proved particularly important given the, as I've said, regrettable delays to delivering the regeneration project. Nonetheless, that course of action has had the consequence of increasing the number of interests to be included in the order. Anyway, the figures show that the decanting process has already substantially succeeded, or arrangements already in place for the rehousing of the vast majority of both secure and non-secure tenants, and the majority of the latter, that is non-secure who have been rehoused, have been upgraded to secure tenants, is the information is in that document. We refer here to inquiry document 44, which is the Council's response to particular points of fact in relation to individual tenants. And we have, however, picked out 2 in particular. That is not in any sense saying the position of the other tenants is any less important, because it plainly isn't. But we refer to these in closing because they're perhaps a particular concern. First, looking at Ahmad, who is very concerned. You heard from both of these in evidence, both of these ladies in evidence. She's very concerned that her health would be adversely affected and her family links damaged by any move from the estate. As a resident of Walnut Close, Ms. Ahmad won't be moved till the end of 2017. At that stage, the state of her health, her family circumstances and her local support network will be taken into account in allocating her a new property in accordance with the housing allocation scheme, as it would indeed be with any tenant. She noted in her statement the importance of her current location in relation to her family members who all live in Barnet within 30 minutes of each other, is her evidence. She added in evidence in chief that if she feels unwell and has to call her brother, he's able to be with her in 30 minutes. And just noting that, of course, no promise can be made at this stage, but given the circumstances that she described in her evidence, and the fact that to date all but 1 of the non-secure tenants who have been rehoused have been given accommodation in the borough, there's a good chance that she will be rehoused no further from her family than she is at present. Hendon Noah, we also say something about in closing the position in relation to her, at your request, Madam, in that was clarified in inquiry document 14, that her position is also covered in the later document number 44. In short, she's been offered a new build Metropolitan Housing Trust property on the estate in Gadwall House, which is both close to her current accommodation and has been assessed as suitable for her needs by the Barnet Thames Medical Assessment Team, which undertook a detailed review of her medical evidence. So, with that, we're going to turn to consider a variety of further matters, including education, community facilities, highways, and so on. I won't read them out because we're coming to them. These considerations do involve contributions to the promotion of social well-being, but we note at the outset that they were all considered in substantial detail through the Council and the GLA's assessment of the planning application, and we submit that no considerations have come forward as a result of the CPO process, which should lead you all, so to say, apart from the assessment that was made at that time. So, phasing already touched on. Quite briefly, therefore, Mr. Paladine has explained that the scheme is split into a number of delivery phases. Completion of all phases is necessary to ensure the developer makes a return on its investment. What are the well-being benefits associated with the phasing? The 106 agreement requires additional affordable housing or affordable housing contribution towards affordable housing provision elsewhere in the borough to be provided if the viability of subsequent phases 4, 5 and 6 of the project improves. Phasing allows the early rehousing of secure tenants on the estate and does so in most cases in a single move. Phasing allows the maintenance of infrastructure throughout the works, for example the provision for the temporary community space, which we deal with in more detail below. And then more generally, we submit phasing allows for the minimising of the works in relation to which compulsory purchase powers are required. Education. At present there are no schools on the estate. The position was assessed in detail in the environmental statement. A general undersupply of primary school places is noted in the document to which we refer, the environmental statement. That position has been addressed through the 106 agreement, which provides for construction on the estate or a suitable alternative location of a 2-form entry primary school, providing 420 spaces in a nursery. The 106 also provides for education contributions amounting to a little over £5 million to be paid in instalments, which facilitate the interim provision of primary school places through expansion of existing local primary school until the new school is built. The provision of the new school, together with the educational contribution, constitute very significant contributions we submit to social well-being. So far as secondary school capacity is concerned, well, that was assessed in detail in the environmental statement, and the requisite local capacity is available. 124 pupils are predicted as against an existing capacity of 3,596 places. Community facilities. There are presently 3 community facilities which serve the estate. The West Hendon Community Centre, 149 square metres, used as such. The Markham Centre, 478 square metres, currently let to a religious organisation, and 189 West Broadway, 169 square metres. The officer's report explained the components of what the scheme will provide in terms of community facilities. On-site, I won't read this all out, on-site provision of a new 500 square metre community space adjacent to the primary school and 304 square metre community space in block 5G, which is going to be permanent as long as it's used. The main community space, if I call it that, comes in phase 5, and the nature of that space is there explained. I won't read the rest of that paragraph. In fact, I think I can take, if I may, the whole of that rest of the citation from the officer's report as read, because we ourselves in the submission do a little bit more detail in paragraph 99. So far as the temporary community facility is concerned, should a need be demonstrated in the 106 agreement, the 106 agreement requires the provision of such a facility prior to the occupation of any phase 3C unit, and the facility must be retained until the new community centre is available. Another community facility is provided by the council elsewhere, or until, or for 8 years, whichever of those things occurs first. The temporary facility is going to be 169 square metres, the same as the 189 West Hendon Broadway community space, which is going to be demolished during phase 3. So there will be no net loss, subject to the proof of need in community floor space within phases 3 and 4. And the resulting facility after phase 5 will obviously be modern, purpose-built and multifunctional space. It will be a lot higher quality. And that was found to be acceptable right after we submitted at the time of the planning application. Healthcare, that was assessed in detail as one would expect in the environmental statement. Spare capacity at the 11 GP surgeries within 2 kilometres of the estate for some 15,000 patients, an estimated 5,180 gross new residents associated with the scheme. So any additional demands can be accommodated. That was the analysis in the environmental statement. The officer's report, given existing surplus capacity at both local GP and dentist surgeries, the scheme's impact on health facilities will be minimal if any improvements to health infrastructure are found to be required at a later stage, and the borough's sole charge, as guided by the infrastructure delivery plan, is a potential source of funding for those. Highways. The highway works proposed as part of the scheme is set out in detail in the transport assessment. The impact assessment in that document, which is section 7, concludes that when measured against the baseline position, the scheme will bring about improvements in capacity at junctions, general traffic and journey times. The TA transport assessment included express consideration and analysis of the effects of the proposed removal of bus lanes, which is an issue that has been raised in the inquiry we give the reference. As Mr. Wild's evidence explains, in order to enable the development of phases 3B and 3C of the scheme, the developer will seek a programme of highway closures and diversions, but the need for the orders is unlikely to constitute an impediment to scheme delivery. Public transport, that again was comprehensively assessed, as one would expect, in both the transport assessment and the addendum to it. Summarised in the officer's report as follows: this 106 agreement requires the developer to pay a bus service capacity contribution of £450,000, which will fund the provision of an additional bus service. In addition, the 106 requires the payment of a further similar sum, £450,000. That's called a bus service impact contribution if further assessment shows that additional bus services are required to maintain reliability given the removal of the bus lanes on the A5, and that's intended to deal with any delays brought about by the closure of the bus lanes, if any are identified at the reserve matter stage. As I said before, that's covered in the red. Rail, data received from TfL demonstrates there are no rail capacity issues which will arise from the scheme either or for underground railway services. Parking, ratio of 0.8 per unit, parking spaces per unit. There's a travel plan to support that. The objectives of the travel plan are set out in CDP 17. Those objectives include discouraging travel by car and minimising the need for parking in accordance with current policy. The Council's officer found that the proposal for both the hip and cycle parking were policy compliant, and Transport for London also considered the provision to be adequate. In addition, the developer confirmed in an inquiry document that has confirmed that eligible leaseholders purchasing 2-bedroom shared equity properties can include a car parking space within the shared equity purchase for a shared additional cost of £5,000. Consultation. Well, we've already addressed this, Madam, in a rather more general context earlier in our submission. So, in summary, consultation on the regeneration scheme has been ongoing since 2002. The steps taken by the developer to consult on the planning application were extensive, genuinely so, we submit. See the SCI again. There's an awful lot of points, but briefly, there was this public consultation held in March 2012, invitations sent round to all 680 homes in the estate and also to local stakeholders. I've given the other figures already, so I won't read them again. Public exhibition, 3 months before the planning application itself was made, I think. Invitations to 5,500 residents and to business owners. Meetings, briefings and newsletters involving a variety of local stakeholders, the RRG and West End ward members. Mr. Wilde said that he thought that was significant for application, consultation and engagement. Then when the consultation had taken place and the officer was reporting to the council members on that, he noted that over 8,060 local residents and businesses were consulted by letters posted on the 2nd of April. You have a copy of that letter now, with 341 letters and emails in response. Advertisement in the press, 9 site notices, and obviously full consultation with all of the statutory consultees. Plus, because this is the IA development, application was subject to publicity requirements under Part 5 of the IA regulations. And we submit that the full range of responses was summarised accurately by the council's officer. The application was considered by officers of the GLA and subject to 2 rounds of consultation through its procedures, which brought in a range of comment from still further consultees. What's happened since the 2013 permission was granted, seen Mr. Cowie at RRG and RPB meetings. The partnership board is dealt with in Mr. Cowie's evidence, and there's been a theme that, again, the RRG is not, or the residents on the RRG are not listened to. And it's probably fair to say that this sort of point is always raised in inquiries of this type. That's not to denigrate it in the least, but it is at least to an extent a matter of perception. We merely observe in closing that the RRG has had an impact, and yes, it's been said they've had to work hard for this. Its views contributed to the decision, for example, to exclude Ramsey Close. And we've got the minutes of the most recent AGM. The RRG secured agreement that non-secureds will have their moving costs paid. It confirmed with the council that tenants moving to Skylark Court on a metropolitan tenancy can revert to the council tenancy if they want. Its achievements include also, according to those minutes, setting up a behaviour support group. And Yasmin Parsons couldn't deny that the RRG has fulfilled a valuable function. The second thing that we refer to in terms of what's happened by way of consultation since the planning permission was granted, that there have been site visits and or presentations to the Welsh Harp Joint Consultative Committee, the Welsh Harp Conservation Group, Mr Dismore, and Leader of the Council Alison Moore, and the developers holding an open meeting of residents in the Estates Community Centre, which was attended by more than 60 residents. So, it's our submission at least that from 2002, before, during and after the 2013 Planning Commission was granted, consultation activities have been substantial. Those activities have complied with and indeed exceeded the legal obligations on the council and the developer. The only allegation to the contrary was by Mr Dismore, who said that reballoting was required by law. He didn't know what law, and there isn't such a requirement. Just for completeness, we mentioned that. Social diversity, I mean, much of this really we've covered already, so relatively briefly, the Council's officer noted in the report that community cohesion is a key issue in the redevelopment and re-provision of West Hendon Estate. What he said was the proposed development provided a regenerated neighbourhood within this part of West Hendon, which would result in greater levels of integration with the wider community. Physical accessibility and legibility of the site being improved for pedestrians and cyclists, with significant improvements to connectivity between the estate and open space around the Welsh Harp, and improvements to West Hendon Broadway, improving connections to Hendon Station. The conclusion he reached was that the proposals complied with Barnet Council's equalities policy and the commitment set in its equality scheme. The greater levels of community integration which will be promoted both within the new estate and between the estate and the wider West Hendon area are, we consider and submit very significant wellbeing benefits which weigh in favour of the August confirmation. Environmental benefits. Current condition of the estate, I'm not going to read out paragraph 114 because we've dealt with that matter before, but the considerations include the hierarchy of status, relationship between streets and buildings, the quality or lack of it of the building fabric, and the dominant effects of the perifield wage rate, which of course later in the project is done away with. The scheme's design objectives to address those are set out in CDBO 5, which I suspect is the design access statement. I'm sorry, I can't remember off by heart. The objectives, that is the scheme's design objectives, would not be adequately addressed simply by bringing the estate units up to decent home standards as covered in the evidence. Mr. Shipway's analysis is that even if the required 4.8 million was spent to bring the estate units up to decent home standards, some 6.6 million, including a substantial leaseholder contribution, would still need to be spent on external areas, and even that level of improvement wouldn't address, and that this is important, the estate's inherent problems. Mr. Haynes' evidence, when questioned by Yasmin Parsons, he'd seen the problems with 1960s design. As a new generation of architects, we cannot afford to make those same mistakes again. And probably said this already, but Mr. Haynes is a very experienced architect in one of the top practices in the country for projects of this kind. And I'm sure that you and the Secretary of State will give considerable weight to what he said in his evidence. The regeneration project will provide a comprehensive and long-lasting solution to redress the unsustainable design choices of the 1960s and to provide for long-lasting, durable and exceptionally well-designed units in a scheme that will open up the Welsh Heart to the Broadway and create a more legible, secure pattern of streets, all from Mr. Haynes' evidence. A number of objectors have criticised the recent carrying out of works to the electrical rising mains. That's something we need to deal with. I suggest something of an irony that the Council can both be criticised for failing to maintain the state as it would have done had the regeneration scheme not been proposed, yet also for undertaking works when they become unavoidably necessary. In any event, as Mr. Shipway confirmed in his evidence, those works were considered necessary by the Council to ensure that the estate continues to meet the requirements of health and safety legislation. The works have been part of a borough-wide programme to replace electrical rising mains, which was accelerated in 2013 following initial inspection and survey reports, and an increasing number of incidents of power outages and a fire in a similar block elsewhere in London. I think that was Southwark. The Council acted entirely properly, we submit in so doing. Indeed, it would have been irresponsible not to carry out works required as a matter of ensuring the health and safety of the Council's tenants. Public open space. The proposed network of public open spaces, plain spell check for that one, is illustrated in the design and access statement, and we give the reference. It includes a redesigned York Park and a strip referred to as Broadway Place in the building, which links the Broadway to the Welsh Heart strip. It doesn't really do it justice, if you know what I'm referring to. The design and access statement says this will allow a visual connection to the water from the Broadway and the new local centre, allowing the residential development to integrate with the water body. Mr. Haynes' evidence in chief, create that link from the station towards that fantastic green space. He explained it by reference to the drawing. When you're at Broadway, you can look over the site and you have a green space beyond inviting you into the estate. The two bridges proposed in the scheme will allow and encourage direct access to playing fields and green spaces to the west of the Welsh Heart Reservoir. Now to the vexed subject of York Park. Again, quite a lot of inquiry time has been dedicated to the scheme's impacts on York Park. We do suggest that's surprising for two reasons. One, it's not actually included in the CPO. But secondly, in any event, the scheme provides for its enlargement and improvement, redesign if you will. We cite the design and access statement, which explains what is proposed in this respect. The park will be more outward looking. It will encourage more use of the West Hendon playing fields. The park is going to extend the whole length of the site's boundary. The area will slightly increase, and so on. That's in the design and access statement. I won't read the rest of that out. we now turn just to deal with the evidence. In our submission, Theresa Musgrove's evidence made repeated but unsubstantiated accusations that the inquiry has been misled on the status of York Park. If one looks at the facts, which I suggest is important, the position is actually straightforward and should not be contentious if examined in an objective manner. First, York Park predated the Second World War. It appears on an OS map from at least 1935. Second, the tragic bomb attack in West Hendon in February 1941 took place in the north of York Park. Third, there remains no evidence of any designation of York Park as a memorial park. It appears that a memorial service was held there in 1950, but there is no evidence of any such activities taking place since then, either in York Park or elsewhere. Since 1945, that's a broader point, it's clear from that document, the York Park document, that parts of the northeastern side of the park have been built on, as has the area which the bombs destroyed. This scheme is one of hundreds, if not thousands, of instances of the continuous rebuilding, regeneration and reshaping of London's built and open spaces which has taken place over the 70 years since the war ended. And we have to say that the Council has not emphatically not misled the inquiry on whether the scheme would include works for York Park. The 2002 pledge document made clear that York Park would be redesigned and relocated. The subtitle to the figure at page 7 reads "Homes overlooking the new York Park." There's no reference in the document, as Jasmine Parsons has accepted, to York Park not being touched, and the pledge was clear that it was to be redesigned. The statement of reasons refers to the improvement of York Park. The statement of case made clear that part of the existing York Park would be reconfigured. And we submit that the reconfigured York Park will have a variety of advantages over the existing space, as well as the increase in area. As Mr. Haynes said in the evidence in chief, its new design gives everybody access to the edge of the triple SI. Now, Jasmine Parsons, in her closing statement, deals with York Park on the first and second pages. And she said, contrary to this latest phase, the Department seemed desperate to ensure, this is from page 2, the CBO is put in place to ensure the scheme which is reliant on being able to build on YMP or Memorial Park. The proof is clear in the two-line statement, CDB 24, Environmental Study, Vol. 2 of 2, Appendix 14.1, page, it says, page 227, Historic Parks and Gardens. Now I take you to that document and show you what it actually says. So this is volume 2 of CDB 24, Environmental Statement and Addendum. There's a second of the very fat files that form part of the environmental statement. And Madam, I haven't been able to find page 227, but I have located what I think is a relevant bit in Appendix 14-1. So, Madam, the best way to find it is probably after there's a whole watch of plans about 2/3 of the way through the document of A3 fold out plans, photographs and other material of that kind, well beyond that in the document, much further on, it's over halfway through. It isn't very defined actually. It's further on than that actually. I mean, there are various watches of plans, so my description probably doesn't help very much. I mean, as I make it about 2/3 way through the document, it says Appendix 14.1, ERMES Cultural Heritage Chapter. Do you want to hand it to me when you found it? Just hand it. Do you want to hand it to me? No, hand it to me.
Apologies for interrupting. It seems the page number was written down incorrectly.
That's all right.
277.
Yes, thank you. All right, it won't help you to find any quicker at all. All go. Trouble in finding it. Sorry, pause, but it's necessary to deal with this.
Okay, next time you need.
I found it. Right. There we are. Appendix 14.9, ERS Cultural Heritage Chapter. 3 references, if I may. Page 265, paragraph 14.3.5. This is in a section headed Historical Background, Post-Medieval and Modern. The 3rd paragraph says, Madam, from the mid-1890s onwards, the site's been developed and redeveloped for predominantly residential uses. In its first phase, development was based on numerous parallel roads set out perpendicular to the Edgware Road and aligned with the earlier field boundaries. Rows of terrace houses were constructed fronting onto these roads where there was a mission hall, church and a school. Construction of these houses is more or less complete by 1914, with only a few areas remaining to be infilled in the 1930s. However, the site was not completely built up, and some open space, the York Park Recreation Ground, was retained between the houses and the reservoir. And then there's a second phase with demolition and the rest of it. That's the first reference. Second reference is on page 270. This is in section 14.5, which is headed Methodology. And 14.5.5, page 270, under the heading Historic Landscape Designation, says the following sources were consulted: English Heritage National Monuments Records Swindon, English Heritage Register of Historic Battlefields, and English Heritage Register of Parks and Gardens of Special Historic Interest in England, which is what Jasmine Parsons referred to in her closing statement. Go then to page 277, which is the page that she, I'm told, intended to refer to. I could work that out. Page 277. Just above the middle of the page, 1462, just above 1462, and this is under the heading of designated sites. Shelley mentioned historic parks and gardens. There are no historic parks and gardens within the study area, and this issue is considered no further. So if, as I infer, Ms. Parsons had thought and is telling other people who are attending this inquiry that it's a designated historic park or garden or park, it isn't. That is precisely what it is not. I'm now going to turn to construction impacts, page 37, paragraph 124 of my submissions. Now we have a replacement page for page 37 because paragraph 125.3 had a note which remained to be confirmed and shouldn't stay in. I don't mind people reading what it's in the slightest, but I'm going to replace the original page of 37 and 38 with a new page 37 and 38. So, apologies for that.
With a spare copy of Manchester, can't do that one.
So if everyone could replace, and the version you'll get by electronically will obviously have this new version where that question has been resolved. Just one sec. Construction impacts. Madam, page paragraph 124. A number of objections have raised the adverse impact on them of ongoing construction activities in relation to phase 3A, for which, as above, that is, as we said above, construction has already commenced without need for the exercise of compulsory purchase powers. Construction works on phases 3B and 3C are subject to conditions 8 and 9 of the Planning Commission, which require, again, I'll try and summarise these, a site-wide construction environmental management plan to be submitted and approved. That covers a range of matters. You can look at the condition, restriction on hours, and obviously the developers have to comply with that condition. But residents, if they have concerns, which they clearly do, on whether those obligations are being met, they can contact the site manager directly, they can call or email the developer's communications consultant who will contact the developer, obviously, and or contact the enforcement team, which ultimately, if conditions and elements of the construction environmental management plan not being complied with, is what would be required. In addition to the site-wide CMP, the developer has to produce a construction method statement for each phase, which must include details of how the construction phase accords with the principles set in the overarching document, the Construction Environmental Management Plan. The Construction Management Plan in relation to phases 3B and 3C is one of the reserved matters which Mr. Wilde referred to in his evidence in court, and is required before the commencement of either of those phases. It's not part of the current reserve matters submission, but it will need to be before either of those phases can be commenced. Madam, as to the evidence for the inquiry on current construction impacts, the first point we make is that any adverse impacts on residents are absolutely to be taken seriously, and that the CMP seeks to mitigate or avoid them wherever practicable. That said, we note and invite you to note that the ongoing construction of Block E2, which you will have observed yesterday, will proceed to completion regardless of whether or not the order is confirmed. Thereafter, which is what you are concerned with in subsequent phases, in relation to the properties that will remain in Tyrrell Way for the time being aren't being demolished, the construction activities will be located considerably further away from the impacted units than Block E2 is to the nearest units in Tyrrell Way, which is the point we're making. Daylighting and sunlighting. Daylight and sunlight issues were considered in detail in the environmental statement. In particular, the impacts assessed were found to have negligible daylight and sunlight impacts, and impacts during enabling works will be beneficial because of buildings being taken away. The Council's planning officer considered the impacts in his report. Those impacts including impacts on existing properties that are to remain for the time being, that is until later phases in the scheme, and they were found to be acceptable. Just pausing there. Just to be quite clear, Mr. Knowles in his closing submissions at page 15, in the first paragraph under section 10, said in cross-examination Mr. Haynes he explained that the study that would mitigate effects on the new build's properties, but made no reference to the effect on existing properties, some of which are phased for demolition in 10 years' time from now. If Mr. Knowles is saying that the daylight and sunlight study that was undertaken at the time of the planning application did not consider the effect on existing properties, if he's saying that, I don't quite understand that sentence, but if he's saying that, then he's wrong, because he did see the references in our closing. Welsh Harp Triple SI, the scheme's ecological impacts were assessed by expert consultants, again as part of the environmental statement. What were the key conclusions? Impacts resulting from construction will have no significant effect on peak features of the ecologically important area. Impacts on key species of birds, that's not including species of birds, impacts on key species of birds which the Triple SI is designated will be short-term, the effect is not significant. Again, in both cases, that's a near certain prediction. There are no, that's the way these things are done, there are no significant ecological effects during or at the end of phase 3 or any valued ecological receptors associated with the application site or the Triple SI. Notwithstanding those conclusions, Condition 40 of the 2013 Commission requires the preparation of detailed mitigation strategy prior to the commencement of development works works that may result in impacts to breeding or wintering birds within the SSI to be agreed by the Council. It has to be written in liaison with Natural England, and the Council's consideration of it must be in consultation with Natural England. As the Council officer explained in his report, Mr. Wilde again, subject to condition 14, conditions on artificial nesting habitats and the requirement of the long-term management plan to offset the negative impacts from recreational activity. Natural England withdrew its original objection. The full suite of planning conditions which address potential nature conservation impacts, including lighting effects, were in conditions 39 to 45. Mr. Samuel's allegation, apostrophe is in the wrong place, my apologies to him. Paragraph 17 of his proof that the scheme is causing unlawful disturbances to flora or fauna within the meaning of section 28 P6 of the Wildlife and Habitat Act 1981 is completely unsubstantiated. That provision makes it a criminal offence intentionally or recklessly to destroy or damage protected flora or fauna. The 2013 Commission plainly did not authorise the commission of any criminal offence. On the contrary, the stated purpose of Condition 40 is to ensure that there are no significant impacts in the demolition and building works and other construction noises on the breeding or wintering birds within the SSI, and that on-site ecological features are protected, enhanced, created and managed in accordance with the relevant policies. And it says, of course, if anything is done, it would be a criminal offence which would be dealt with under the 1981 Act. So any well-founded allegation of breaches under section 28P6 of the Wildlife and Country Act that would require criminal investigation will be dealt with under the provisions of that Act, but there is no such well-founded allegation here. And the acceptance of Samuel in cross-examination has been given a full opportunity, indeed 2 opportunities, to raise his objections both orally and in writing before this inquiry. That's nothing to do with the SSI, but more general point. Okay. I'm told that, and if I should pick this up, I'm sorry, the of course bit is not in the explanation for condition 40, or the reason for condition 40, it's our observation or our submission. So we're in the final version, we'll stop the quote at 719 of the London Plan and we'll transfer of course down to the beginning of the next paragraph. Economic benefits. We're not getting there. The starting point is the current economic position on the estate and in its surrounding area. The correlation between Barnet's largest social housing estates and high levels of socio-economic deprivation has been recognised by the Council for many years. We've dealt with that point already, referred to the 2000 housing strategy. The Council's concern over that deprivation led to its formulation of regeneration plans for the estate developed and I think what that should say is, I'm sorry, the grammar's very bad. The Council's concern over that deprivation led to its formulation of regeneration plans for the estate, and it developed housing policies that were aimed at achieving that. We will do a suitable reword in the final version, that's certainly what we intend. More recently, the Statement of Reasons says that crime rates are higher in West Hendon than any of the surrounding neighbourhoods, and it is, I'm afraid, amongst 40% of the most deprived areas nationally. Convinced by that quote. Anyway, we'll have to check that. Back to our text. It's from the Statement of Reasons and can be checked. Redressing that deprivation by promoting economic benefits in and around West Hendon is one of the scheme's central objectives. Those benefits will be many and diverse. Some will result directly from the social and environmental benefits we've already mentioned. They will include bringing about increased economic activity in West Hendon through new retail provision, greater spending power, more retail units, more employment. Mr. Caddidine's evidence, there will be significant economic benefits, 16,000 square feet of new commercial premises, 1,500 additional properties on the estate and currently there. The economic spend in the retail district will be very significant. In addition, there was this sample, no more than that, test, where we looked to see how many people were working on the site. We quizzed the first, I've gone off for like, nobody complained, don't blame them. We quizzed the first 150 people through the door and found that 21% lived in NW9 or immediate areas around it. In addition, the scheme makes provision for a number of retail units alongside its playgrounds and outdoor amenity spaces, design and access statement, Mr Haynes' evidence. Broadway places a new urban space surrounded by commercial units at the ground floor, creating the start of the regeneration of commercial units along Broadway. It will also create the opportunity for commercial activity like restaurants and cafes just off the busy road. Mr Cowley's evidence in question by Mr Cowley was that the scheme will bring about a significant uplift in general attractiveness of the area, to which we think Mr Cowley's replied, we're all for that. That's consistent with one of the central economic opportunities identified for this area in the design and access statement, namely to improve the commercial viability of the retail and commercial units on the Broadway through increased population on the site. As a matter of planning policy, alongside the creation of new homes, G, Crick and UDP made the Cricklewood, Brentcross and West Central regeneration area a major focus for the creation of new jobs. Through a very significant increase in local spending power, the creation of retail units, the provision of community infrastructure, including the new community centre and school, the scheme meets that long-term objective policy, long-standing objective policy, and will bring major economic benefits to West Hendon and beyond. And we mentioned the obligation of the 106 to pay a total of just over £500,000 towards recruitment, employment and training initiatives in the borough. Likelihood of scheme delivery. This is the third factor in the circular Appendix A, paragraph 16. And what does it say? It says that the Secretary of State will consider the potential financial viability of the scheme for which the land is being acquired. Why would he do that? That's my interjection. A general indication of funding intentions and of any commitments from third parties will usually suffice to reassure the Secretary of State that there is a reasonable prospect that the scheme will proceed. Madam, the promoter's position as we submitted in April is straightforward. The scheme will proceed if the order is confirmed. There's nothing standing in the way of the scheme other than the acquisition of the remaining interest required to deliver it comprehensively. The only remaining impediment, therefore, to the delivery of phases 3B and 3C is the completion of the land assembly process. The developer's commitment to delivery, Mr Caladine's evidence. Planning permissions in place. The land interest for phases 1, 2 and 3 have already been assembled and negotiations for the acquisition of further interests are ongoing. The developer has a wide range of experience of delivering housing developments and regeneration projects, and sales of phases 1 and 2 have been strong. The necessary funding is in place to complete the scheme. Although phase 3 does not meet the financial viability test within the PDA, in itself, the remaining phases of the scheme will provide the requisite commercial return. In consequence, the developer is incentivised to complete the scheme. And there's been no challenge of this inquiry to the developer's ability and willingness to deliver the scheme. It's already delivered the pilot and lakeside phases. It's in the process of delivering phase 3A. It is, madam, obvious that the developer intends to continue through phases 3B and 3C, which are, after all, the elements of the scheme that this order will facilitate, to phases 4, 5 and 6, and thus through to scheme completion. No highways orders are currently proposed, although stoppings up and diversions will in due course be required. Mr Wild's evidence has explained these are unlikely to cause adverse impacts on the users of the highway and therefore I should say, constitute an impediment to delivery, and that again hasn't been the subject of debate or issue or challenge of the inquiry. So, madam, the scheme is the culmination of a regeneration project that's been an aim of council policy for over a decade. It's already commenced with the benefit of planning permission. Sales and construction activity in relation to phase 3A is ongoing. The developer has demonstrated a commitment to delivering the scheme which easily passes the circular test. Any other means? The last paragraph 16 criterion and factor. The scheme has been through the planning process, including EIA, and has planning permission. It remains the case that, as stated in opening, there's no plausible, deliverable alternative to the scheme in terms of continuing the regeneration of the estate. Thus, the only alternative we continue to submit is a negative one, that is to halt the process of regeneration, and who knows what will happen next. The order is therefore necessary as a last resort to ensure that the scheme can proceed. Negotiations. We cite the whole of paragraph 24 of the circular. I won't read it out. We submit that the promoters have acted in accordance with this approach by initiating negotiations to acquire land by agreement about 3 months before the order was made, and by continuing to conduct negotiations in parallel with the CPA process. See Mr Watling's evidence. 31 properties that were acquired by agreement between 2004 and 2008. That's in addition to the properties acquired by the Council in advance of Phase 1. In March 2014, Mr Watling and Capital made approaches to all estate leaseholders as well as Broadway owners and occupiers that we submit plainly constituted the opening of negotiations, that is to acquire land by negotiation wherever practicable. Those approaches resulted in inspections where access could be gained, the preparations of estimates of value, the agreement of agents' fees, and the making of initial offers to leaseholders of estate properties in early June. And the progress of negotiations since the offers, see Mr Watling's evidence and see the schedule. I wonder if I should pause to say, ask whether that's available and whether that might be handed out now.
So it's slightly out of sorts with the inquiry numbers. I think it will become 49.
Brilliant, thank you. Okay, thank you very much.
You agree with that?
This was called document 6. This is updated CD 6. Or am I making that up? Oh, well, I'm sorry, I'm not going to deal with it now, or possibly at all, because it's just an updated. It's just an updated version of the earlier document, and I haven't received direct instructions on it, but if when I finish, you want to know more about it, I'm sure we can help. There it is, can we put it aside for the moment. Paragraph 150. Mr Knowles has criticised the Council for undertaking negotiations in parallel with making the order, but we think that criticism is misconceived. In fact, on the contrary, progressing negotiations in tandem with making the order is expressly encouraged in paragraph 25 of the circular, which we cite. You've heard it before, I won't read it out. The evidence we submit demonstrates that the promoters have taken appropriate steps to comply with these circular guidance and to negotiate where possible and as soon as reasonably practicable. In any event, madam, we do make the observation that the general failure positively to respond to the offers made on the Council's behalf bears out Mr Watling's evidence and re-examinations. It's most unlikely that more agreements would have been reached by the time the inquiry opened had first offers been made earlier, or indeed by the time the inquiry closed. 3 further points, if we may. The number of objectors, a number of objectors to the order's confirmation contested the level of the promoter's offers. Madam, as you made clear on the first day of the inquiry, the inquiry is an evaluation tribunal, obviously can't decide on the appropriate valuation of individual interest, and Mr Knowles made it clear that he took no issue with that in his evidence. But Madam, Mr Watling's evidence does demonstrate, we submit, that genuine efforts have been made to acquire interest by negotiation and thereby to resolve objections. Negotiations have continued during the inquiry. They'll continue after its close and up to vesting if necessary. The requirements of the circular have been met. Second, the question, Madam, for you and the Secretary of State, we suggest is whether the promoter's efforts to negotiate have been reasonable and undertaken in good faith. On that, Mr Knowles accepted in cross-examination the differences between him and Mr Watling were matters of professional judgment, matters, that is, on which reasonable professionals can and often do disagree. Professional disagreement on values is certainly not evidence that the Council's efforts to negotiate have been anything less than genuine and reasonable. Thirdly, we would observe that any criticism Mr Knowles makes of Mr Watling's approach to negotiation must be tempered by, I should say, Mr Knowles' failure to make any counter-offers or otherwise to identify any figure that would be acceptable to his clients. It's no part of the guidance in the circular to require one-sided negotiation. The promoter's wish to acquire land by agreement wherever possible is evidenced by what's happened, the acquisition by the developer of the Capitalist site, the agreements reached with Canal and River Trust to do with the bridge and the Deerfield site, road widening later in the scheme. In relation to Deerfields, it's anticipated that completion of the acquisition of the land will take place within the next 2 months. Human rights. It's now well established that the test to be applied in considering whether to confirm a compulsory purchase order, namely whether there is a compelling case of public interest for it to be made, satisfies the balancing exercise required when considering whether interference with human rights under Article 8 and or Article 1 of the First Protocol is lawful and justified, and that doesn't constitute a breach of the Convention. In all cases, the making confirmation of the CPO to require private interest in land must be shown to be justified in the public interest. Striking a balance between public interest and private rights is thus not only a requirement of the circular and domestic law, it's also necessitated by the Human Rights Act and the Convention. It's our submission that the very significant public benefits that the scheme will provide by securing the regeneration of the orderlands justify the inevitable interference with individual rights that will result from the confirmation of the order and the exercise of the powers conferred by them. That always sounds like a bit of a sort of incantation, and we don't put it forward as an incantation. It's the right way to express the point. We think that obviously we're not at this stage going to go over again, goodness me, the benefits that we say are present if the scheme is allowed to go ahead. But that is the correct approach we submit to assessing the balance between private interest and public benefit, and we invite that conclusion and don't need to add anything to that in the light of what we've already said in a lengthy submission. Now we return to the question of disclosure requests, because we'll see why, but we think we need to do that just to make the Council's position very clear on this. In doing this, I'm going to have to say one or two things about Mr. Knowles' submissions on this. As we previously mentioned, Madam, you and Secretary State need to be satisfied that there's a reasonable prospect the scheme will proceed. We've dealt with that. And we submit, on the basis of that evidence, it's clear that it's likely the scheme will proceed to completion, not actually only phases 3B and 3C, which will be facilitated by the order, but also the later phases for which the further exercise of compulsory powers is likely to be required. It's important to appreciate that it remains the case that none of the objectors seeks to demonstrate or even to assert that the scheme, phases 3B and 3C in particular, is unlikely to proceed should the order be confirmed. In this respect, and that is in respect of the requests for disclosure that you have had, the Council's relied on its two position statements, which were provided in response to requests made for the disclosure of viability studies by Yasmin Parsons, Derek Chung, Mr. Calley, Councillor Landell, and more recently Mr. Turner. Following consideration of these requests and Council's response, Madam, you have declined to exercise your powers under Section 250, subsection 2 of the Local Government Act to require any viability studies to be produced for the inquiry. And in response to a point made by Mr. Turner, we would say this, and we would submit highly unlikely event. Indeed, we think this would be quite unjustified. That the Secretary of State considers that he needs to see any viability material before making his decision on the order. He is invited not to refuse to confirm the order, but to indicate his view accordingly to the parties and invite representations on how to proceed. But we don't think there's any justification for taking that course now. In the light of Mr. Turner's more recent intervention, perhaps it's important briefly to reiterate the basis on which the Inspection Secretary of State were invited to conclude, without needing to see detailed financial viability information, that there's a compelling case in the public interest for confirmation of the order. Madam, the Council has provided substantial evidence to the inquiry on these two matters. First, likelihood of scheme delivery, which includes its potential financial viability, see Section 6 and indeed paragraph 156 above. Second, the Council has provided substantial evidence to the inquiry on the extent to which the scheme fits in with the planning framework for the area in terms of compliance, in particular with affordable housing policy, Section 5 of our submissions. In this respect, Madam, the Council's case is based on the assessment, both by itself and the GLA, of the affordable housing provision, proposing the planning application. The developer's viability material is independently appraised, and it's concluded that the provision of 25% affordable housing across the scheme in the mix proposed, and in accordance with relevant definitions in the London Plan of affordable housing, was policy compliant. Now, Madam, it remains the case, as we submitted in opening, that the Council's position is that the scheme is likely to be delivered. And Mr. Caliban's evidence in support of that hasn't been the subject of any substantive challenges we've said. That is also true of the position in respect of affordable housing provision, which was an issue that was determined at the time of the planning application in the manner explained by Mr. Wilde. The only challenge, in inverted commas, to what's been done has been by way of requests for viability information, which was taken into account at the time the planning application was determined. But these do not, in reality, constitute a challenge in the sense of evidence which substantively puts at issue the reliability or accuracy of that information. Rather, they are the fishing expedition of precisely the type which Mrs. Justice Patterson, in the Perry case, said that the parties should not be allowed to go on, to use her language. And whilst what I'm about to say is covered in the Council's further position statement, it's also perhaps worth reiterating that it would be quite erroneous to draw anything from the Shell Centre case in the High Court until judgment has been handed down. That case, in any event, concerns the grant of planning permission by the Secretary of State, and so may well have no direct bearing on the present case. I'm going to come back to that in a moment. I'll just read B. The facts in the Tottenham CPO case were very different from those in the present case. There, the CPO was confirmed in circumstances where part of the development, phase 3, could have supported some affordable housing. Everyone accepted that, yet the scheme as a whole included no affordable housing mechanism at all, and included no review mechanism either, and was thus found to be non-compliant with policy, and yet the CPO was confirmed. Now, I need to go to some slightly extraordinary things that Mr. Knowles has said in his submission. On page 9. Madam, first of all, Mr. Knowles said Mr. Turner also helped you propose a queen on the application of Perry in the London Borough of Hackney, where the High Court is currently considering whether the respondent is obliged to receive and release a viability report. Mr. Justice Collins advised that had the promoters not released the viability report, such a state would have no defence for it. It's not a Perry case. Perry case is a completely different case. It's about the Shell Centre. It's a claim that's brought by Mr. Turner about the Shell Centre. Perry is a decided case of the courts which we have dealt with in our position statement. So that is a wrong reference. Fine, it doesn't matter, but it is a wrong reference, and we wouldn't want anyone to be misled by that. But perhaps, possibly, potentially more importantly, is the next paragraph, which bluntly is completely wrong. Though accepted, he says, Mr. Knowles, the statement is likely to be made in obiter dicta. The case has not yet been decided. It's unclear, therefore, whether it will in time afford part of the ratio decidendi and therefore be binding. However, even in obiter, it's persuasive, one of the most well-known legal principles, that of promissory estoppel is an outcome of a statement made obiter dicta by Lord Denning in the High Trees House case. Well, obviously, first of all, I don't think Mr. Knowles is suggesting that the concept of promissory estoppel has anything whatever to do with this case, but in case he is, then he doesn't. But what he is saying is that the remark by the judge, which Mr. Turner says the judge made during the course of argument, constitutes obiter dicta. It doesn't. That's a fundamental misunderstanding of what obiter dicta are. I'm sorry to have to go into this. Actually staggered to find myself going to do this in the CPF inquiry, but there we are. An obiter dictum is, and we've looked at Jarrett's Dictionary of English Law, and it may be as well if we make Mr. Simon's copying out of Jarrett in his excellent handwriting inquiry document. Jarrett's Dictionary of English Law defines an obiter dictum as an opinion not necessary to a judgment, and therefore not binding as precedent. So, Mr. Justice Collins' judgment may be full or not of obiter dicta, that is, remarks that he makes which were not necessary for the purpose of deciding the issues before him. The ratio decidendi case is the judge's findings, which conversely are necessary to his decision on the case. But they've got to be a judgment. The very idea that judges' remarks during the course of argument can be used later to support or not arguments that are made by parties, whether in court or elsewhere, is quite fantastical. The whole English legal system would literally fall to the ground if that was the approach to be followed, because judges are extremely interventionist, many of them, during the course of argument. And they make remarks which they may either not mention in their judgment, or they may say, I had thought, I had been persuaded during the course of hearing that, but I have decided that is wrong. So if, Madam, with the greatest of respect, you or the Secretary of State gives any weight whatsoever of any kind to what Mr. Justice Collins is reported by Mr. Turner, amongst no doubt many other remarks he made during the course of the case, to have said during that hearing, then you will be falling into serious legal error. In a sense, this is unimportant because the judgment will be out soon, and it may or may not be something the Secretary of State will need to look at, but that we don't know yet. So, with that, I'll return to paragraph 162. The Secretary of State is therefore advised to find there is a compelling case in the public interest for confirming the order on the basis of the evidence that's been provided to the inquiry by the Council. So, finally, except for our mercifully brief conclusions, we deal with the compelling case test. Before I do that, actually, I think I'll pick this up now. On page 1 of her statement, Yasmin Parsons made this allegation. LBB has a history of being found guilty in court for deliberately withholding information and deliberately misleading. Now that is another serious, but as things stand, entirely unfounded allegation. I've taken instructions, and my instructions are that those who are present at the Council do not know what she is saying. So all I can say at the moment is that is an unfounded allegation which is not accepted. I don't know how it could be taken any further. Maybe it should be taken further outside the inquiry. It's a new piece of evidence, actually.
It is, and we've had a discussion about saying things that are inappropriate.
It's an entirely new piece of evidence, and it's unfounded, and I'm unable, my instructions are, as I say, that we are not aware of what is being referred to. I just simply leave it at that and say no more about it. Section 11, compelling case of public compulsory purchase is recognised in policy as a positive tool in planning to secure public benefits in compliance with policy objectives. The use of CPOs to secure appropriate regeneration and improvement in urban locations is very well established, and the Secretary of State recognises the critical role that compulsory powers can play in securing economic and social progress. Right at the beginning of the circular, ministers believe that compulsory purchase powers are an important tool for local authorities and other public bodies to use as a means to assemble the land they need to help deliver social and economic change. They can revitalise communities, promote business, etc. I won't read it all out. Madam, the principal reason why the order is required to enable land assembly and sufficient rights to be acquired so that the scheme may proceed in a timely and well-planned manner is in order to bring about public benefits to the area. The exercise of compulsory powers in short brings certainty that the scheme can be delivered. Given the number of interests in the land, the promoters cannot be expected to acquire all of those interests by a private treaty within a reasonable period of time, if ever. As we've submitted, reasonable efforts have been made and will continue to be made to acquire land and the rights necessary to carry out the scheme by agreement. In reality, the period of negotiation will continue until vesting. However, it's obvious that the order is required to allow this to occur in a timely fashion. That's why the Councils follow the appropriate statutory procedures to make the order alongside negotiations with affected landowners, as the circular advises. drawing threads together, wellbeing benefits. I'm not going to read those again because I think we've had those, if you'll forgive me, but they are important. The scheme will create a more attractive, vibrant and sustainable neighbourhood through this high design standards and improved mix of housing tenures and sizes, improvements to public realm, excuse me, and overall more balanced and inclusive community. That is our evidence. And those contributions to the social, economic and environmental well-being of the area amount to a compelling case in the public interest in our submission. The importance and urgency of regenerating the estate have been recognised in planning policy over a number of years. The regeneration benefits brought about by the scheme are critical not only to the estate but to West Hendon more generally. If the order isn't confirmed, the scheme can't proceed. And if it doesn't proceed, and the order is not confirmed, we identify these adverse consequences. The only opportunity that's on offer to regenerate the estate in accordance with the objectives of the London Plan, the core strategy in some 15 years of council housing policy will be lost. The regeneration process will come to a halt, leaving a part-completed project and no alternative means of continuing it in prospect. There's just one other thing that I should have mentioned before we go into the brief conclusion. And it really, I should have raised it earlier. In relation to non-secure tenants, on page 14 of his submission, said under insecure tenants, we've heard, this is in the middle of the page, the third paragraph under section 9, we've heard Mr. Shipway's evidence and cross-examination with Parsons, which referred to which referred to insecure tenants being offered one choice that we had, and while secure tenants are offered 3. Just by way of clarification, the offer of 3, the choice of 3 properties to secure tenants is not a statutory requirement. It goes beyond what is statutory required. So just so you're clear as a matter of fact, that that process by which secure tenants are asked to list an order of preference 3 properties does go beyond what the council is required to do by statute. And with that, we conclude that there's a compelling case in the public interest of the confirmation of the order which justifies the acquisition and override of private rights. There are no material obstacles to the implementation of the scheme other than the confirmation of the order. No alternatives to the scheme exist. The statutory requirements are satisfied because the order will facilitate the continued development of the scheme and because it will contribute to the economic, social and environmental well-being of the council's area. There are no new considerations which would justify a different approach being taken to that of the council when it grants the planning permission. The policy requirements of the circular for the confirmation of the order are satisfied. The confirmation of the order will be consistent with and not breach the framework and development plan. The interference with the rights of those whose interests are to be acquired pursuant to the order is justified in the public interest, and a failure to confirm the order would have serious implications for the estate of the West Hendon. Moreover, the many public benefits as described above in the evidence will not be realised. So for the reasons we've given in the evidence, we do submit as a compelling case in public interest to confirm the order the huge range of benefits that will flow from the confirmation of the order is sufficiently justified interfering with the human rights of those of interest in the order land, and accordingly we request the Secretary of State to confirm the order. And that concludes our closing submissions. Can I just say a couple of other things? I'm very sorry if Ms. Parsons, as she has found the behaviour on the part of, I'm not quite sure who, inappropriate. It certainly wasn't intended. And I don't, myself, having sat throughout the inquiry, think that there has been anything inappropriate. I'm afraid people do fiddle with their phones these days. No doubt much of what was being done was finding out information and doing things connected with this case. But anyway, I'm sorry that Ms. Parsons has found that. I hope you haven't found that, and certainly no disrespect is intended to anybody, least of all you, madam, or any of the objectors and residents who have attended the inquiry. Can I thank you also, echo the thanks that have already been given to you very much indeed, for what I think we all agree in light of remarks that have been made by Mr Knowles in his past, for the very fair and measured, if I may say so, thoroughly sensible way in which he conducted the inquiry. And I also, on behalf of the Council and myself and Mr Symes, thank all of the objectors who have come to the inquiry, including Mr Knowles, obviously, for the courtesy that you've shown. We really appreciate that. And also for the respect which everyone has shown for the inquiry process, because these cases can be very difficult. This case has been very difficult for a number of people, and we are very grateful for the way that people have spoken and the, as I said, courtesy and respect which has been shown.
Just a couple of matters that we really need to pick up now. The first one actually is really for you, Ms. Parsons, to withdraw that statement.
I withdraw that statement.
Perhaps just keep making note of that in the night.
Thank you.
Take a bit of a heat
I
out
appreciate
that
that,
concern.
Ms Parsons, thank you.
And the second one is just to have a look at the negotiation schedule, and perhaps you can just take us through it. It's matters of fact, so it's not anything that adds or changes circumstances in terms of the statements I've just heard. It's just so that I know clearly what you have updated.
Help?
So if
I don't know, but I can guess.
So if it helps somebody else to tell us, I'm
Yes,
more than happy to hear from someone else.
We're going to just want to just get recall Virginia Black. I think I know, but that's not good enough. I mean, it's much better if she comes straight from, because she's been responsible for putting it together. So can we have a short pause?
No, that's
done.
absolutely
Was there something else that you wanted?
fine. I was just wanting to check my list of things that make sure
While you're doing that, just to say we're going to hand in this remarkable final document for CPA inquiry, Jowett's dictionary definition of a neighbourhood dictum, and that's being printed off at the moment.
so we're running that as inquiry document 50, so that brings us to a round number.
Round number. Better not be any more. I've read that out, so if it isn't actually available by the time we close the inquiry, then perhaps that won't matter. I'm not sure. Did you have anything else that you wanted?
Nothing else beyond that. Do you know how long Miss Blackman's like to be?
Assuming she's not coming from her office in the West End of London.
Seconds,
Bit of a copy of this.
Oh my goodness.
Yeah, did you want to sit there?
This makes more sense for you to tell us.
I've been asked, Ms Blackman, what the changes are,
Right.
and I've said that you're the person who knows.
Well, I'll certainly
You need
guess.
to switch yourself on. Yeah.
Is that working now? Yes. Okay. There are 4 schedules attached to that have been handed in here. Now, the only changes that I'm aware of are on the first schedule, which is estate properties, and the final schedule, which is the Canal River Trust. So we can put the other 2 to the side. Canal River Trust, I suspect, is the simplest one, even though it's last. It's just to give the update on the contract exchange and objection withdrawal, which we previously talked about, but just to update that schedule. Then, in terms of the estate properties, just running through. On the first one there, Freetown Way, in respect of Mrs Adams, there has been some update on negotiations there since the schedule was submitted in the early part of this year. Seven Till Way sets out actually a summary of all the negotiations with Mr Knowles. And there is an update there which talks about all the discussions that have happened since the beginning of the year. Apart from that, there are a number of the properties where Metropolitan have been in contact with the owners to discuss shared equity, and we can just run through from my notes. At 17 Tyrrell Way, there's an update there in terms of MHT. 21 Tyrrell Way, there's an update there. On 22 Tyrrell Way, represented by Robert Clifford, there's an update to reflect the updated offer that went out on the 23rd of January. And similarly, in respect of 30 Tyrrell Way, where represented by Andrew Connor. In respect of 21 Marriotts Close, there is the update which reflects the contract exchanged on the agreement reached with the owner there.
Yes, I've probably, if I'd been alerted to that, I might have put that in the closing. That's quite significant, that last one there. The last entry under 21 Marriotts Close, is it? Heads of terms have been agreed, contract and deed contracts exchanged. 2 or 3 days.
What's the objection withdrawn?
I don't think this was an objection.
That was an objection, okay.
28 Marriotts Close, updated to reflect the 23rd of January letter that was sent out. Those are all 51 Marriotts Close, updated to reflect the 23rd of January letter to the unrepresented resident. '64 Marriotts Close, again updated to represent that. And I believe 92 Marriotts Close, in respect to the shared equity negotiation. And the final page. Franklin House has an update there in respect to negotiations that have happened, which I think reflects a number of the business goals. 45 Franklin House, the letter of the 23rd of January. 52 Franklin House, to update on the shared equity discussions that have been ongoing. I think that covers all of them.
Thank you very much indeed. We've got IMQ 50 printed out, the Jowett extract, Jowett's Dictionary of English Law.
I don't hear from anybody else at this point. Simply matters of procedural fact. In terms of the closing submissions, as I said before, as we agreed at the pre-inquiry meeting, Tuesday for those to go to Jenny Tynan at the planning inspector, and the details on the pre-inquiry meeting note. So it should be clear. To ask if there are any other matters to be raised, and that's essentially costs, applications. I'm not aware of any coming in.
No.
I'd like to thank everybody for their cooperation here, but I'd particularly like to thank the staff at the Town Hall venue because they've been exceptionally good in helping people in and out, certainly helping me with boxes and things like that, and being very pleasant. It's been a nice place to be, so I genuinely like to extend my thanks to them particularly, and I'd like to thank you all for your cooperation. I know it's a difficult sort of subject to deal with. Planning always is, compulsory purchase particularly, so I do understand that it's been hard for people, and I thank you for behaving as well as you have. It's been very well run, and I do appreciate that. And that includes clearly the evening march, which lots of people made a very good effort to make sure that was well run. It was a sensible event, so thank you for that. Other than that, all I want to do is to wish you safe journeys to wherever you're returning. And that concludes the inquiry. I make it 20 past 2, so it's rather late to adjourn. So I apologise for that, and perhaps you'll go get yourself some lunch. Thank you.